with the petitions. Object here, no? Here, this is not here. This side. Yeah. And लिखा है अभी जाएंगे ऊपर ट्रेनिंग के लिए इसे यहाँ नहीं लिखेंगे तीनों आगे सारा उनका अलग रखता है वीडियो पार्टिसिपेंट्स को guys, everyone switch off their phone, put them on silent, and ring the round, we will confiscate the phone. Then everyone put their phone on silent. I don't want any disturbance. And nobody should use their phone during the round. Whoever want to use the phone during the round, they can go and sit in there. Whatever they want to do, but not here. Nobody. If I see any person using the phone, if I see any person using the phone, to take action against them. Also, guys, the people who are sitting there cannot go outside. Okay, once you are in your thing, nobody. इसमें क्या करना है इसमें इसमें से कोशिश है give me the third Harish third laptop सब कुछ आदमी मॉलिंग लगा था बहुत ठीक है बहुत उसका कवर हटा दो उनको बोलते आप कोशिश उनको चेक करो वो
फोल्डर में क्या क्या है अंदर
कोशिश
नोट करना ही
ठीक है it has proposition तुम्हें it is mentioned concepts कहाँ पे है tell them this ठीक है online drive बताइए ना लगा देना इस पे चेक करना लगा देना लगा हाँ लगता है करना मेरे
See, it's all arranged here. Maybe do we responded like just kept it in
Ravi, get on this side. Only, only participants who have gone in touch will enter from that back row. No entry from the school doors. लोग किसके पीछे का भी
जो का तो आया विद मी।
ये यहाँ से होगा फिर भी वो करना पड़ता है। इससे आता है मेरा, मेरे में राइट राइट ऑन, मेरे में राइट ऑन है, मैं ऐसे नहीं चलाता। ठीक है, ये तीनों में करना है, तीनों में करना है। अब वो खोल के काम है अच्छा उधर ही चाहिए वो फिर तो
और बोले बस बंद करके
ब्रदर भैया इसमें भी व्हाट्सएप क्विट करो, व्हाट्सएप और स्पॉटिफाई
All phones should be on silent. All phones should be on silent immediately. All right.
Good afternoon. You can sit for a while again. When they will come, then you get about. I will do this also for marking. Bosa. Well, Hey, you can sit on that. Please take your seat.
Yeah. Yes.
So, what they are using or they are I will write on the public media and proposition. All participants are ready? Ready? Ready for arguments?
There will be time dimensions. So speaker one for the petitioner, you speak for 22 minutes and 16 minutes speaker two out of 400 and 2 minutes they kept available.
There is a breakup in 40.
Yes, there are two speakers per speaker one.
20.
Yes, we have noted the division and we'll be looking at
And
it.
out of three, only two will argue.
One is the researcher.
One.
Speaker one and speaker two will have. And we will split into background.
Okay. This will be. This will be marksheet. This is. Speaker one, speaker two, speaker one, speaker two. This is two plus marksheet, but because we will five numbers. We'll do the play. One to achieve. Here is also break. Yeah, speaker one of it is one. That is one. Speaker that is one. Now it is made. So that is all. Just one. So. All the students are going to be on the which so the all the participants are one to just what the teams are participating. It will do something in school. That the games register yes for the games. I have to do something. Yes, national, international, the first one was the first one, the first one, the Huh? Yes. No, no, okay. Yeah, which I got. After this, already criteria doesn't solve it. She has, you know, just for. Obviously, doesn't have the identify those criteria for.
explicitly mentioned that a power plant should be avoided within 25 kilometers of the outer peripheries of a metropolitan city. Your Lordships, the proposition suggests that Babunagar is a metropolitan city because it's a city, it's the capital city of the state of Puripara, where this particular power plant of 3,400 megawatts, which is a gigantic capacity power plant that is functioning in the vicinity of a capital metropolitan city, Your Lordships, which has caused severe damage to the environment as well as the health of the residents, Your Lordships. Thus, in the present case, the citizens of Babunagar are entitled to compensation with respect to the functioning of the power plant, and the council are seeking that the state of Puripara, which brought in this investment through the public-private partnership, along with the umbrella corporation that has invested and is functioning.
International principle by which you say if somebody causes a damage to the environment is supposed to make the payment. Which is that principle?
Your Lordship, the polluter pays principle, which was laid down in the case of Indian Council of Enviro-Legal Action versus Union of India, where it was laid down, Your Lordship, that it imposes an absolute obligation for environmental harm on any corporation or any entity to recompense pollution victims and to pay the cost of restoring the environment with the burden of preserving the aforementioned balance falling on the unit that created that pollution, Your Lordship. Yes, Your Lordship.
When this plant was commissioned of the facts,
Yes, Your Lordship.
then it was.
The plant was built between 1998 to 2002, Your Lordship.
What is the cost of action you have pleaded in the petition?
Your Lordship, the cause of action is with respect to the destruction and environmental degradation that has led to the jeopardizing the health of the citizens of.
How many years?
Your Lordship, the plant was functioning for 20 years, Your Lordship.
Cause of action arose only after 20 years.
Your Lordship, the proposition suggests that there have been long protests and complaints. Yes, Your Lordship.
You pointed out some page number 62 or 61, where some clearances were given by the authority to set up the plant. The one of the conditions you mentioned that it should not be within the
Yes, Your Lordship.
buffer zone.
Yes, Your Lordship.
Now, whether it was not within your knowledge when the plant was commissioned 20 years before.
Your Lordship, that is a very important question, Your Lordship. Now,
Why did you wait for?
Your Lordship,
There was followed while setting up the plant.
understood, Your Lordship. Your Lordship, the proposition suggests that there are 285 other power plants in the country that are functioning as well. So the citizens of the city living in the vicinity were not aware of the fact that the power plant might prospectively malfunction, because of which this pollution has been caused, Your Lordship. Now, let me cite another example, Your Lordship, with respect to Badarpur power plant, Your Lordship. The Badarpur power plant was decommissioned because eventually, after 20, almost 20 years, if the council is not wrong, after 20 years, in the year 1983, the power plant was decommissioned because the equipment and apparatus had been outdated and the plant was evidently malfunctioning, Your Lordship. Therefore, the cause of action arose towards the end, because the validity of every power plant is 20 to 25 years, Your Lordship.
Whether there is any limitation to invoke writ jurisdiction.
Could Your Lordship explain the question, Your Lordship?
Limitation to invoke the writ jurisdiction of the court.
Yeah, yes, Your Lordship.
Whether there is any limitation to invoke the writ.
Gender limitation.
No, whatever.
Yes.
Gender specific, whatever you.
Yes, Your Lordship, just like the council mentioned that if there is an absence of fundamental right violation, and secondly, if it is limitation.
Like any other statutory provisions, you know that limitation for filing.
Cause of action, my
Ah.
learning is suggesting when the cause of action arose 20 years before, when the plant was commissioned.
Yes, Your Lordship.
So when exactly the cause of action arose and within what period you ought to have taken a remedy by the statutory of the Constitution? What are the pleadings on this issue?
Your Lordship, the
Because I understand is that only after the plant was decommissioned, you came before the court to approach the court. So what is the cause of action?
Your Lordship,
Commission of the plant is the cause of action. Arose soon after the plant was commissioned and you suffered because of some pollutants. What are your pleadings on that issue?
understood the question, Your Lordship.
Because limitation question is raised. That you need to answer first before we invoke or representative of.
Indeed, Your Lordship.
First, you have to tell whether there is any limitation to invoke the writ jurisdiction. Like suppose any other provisions that 90 days limitation is provided, 60 days limitation is provided, 120 days limitation is provided. So whether there is a such limitation for invoking the writ jurisdiction.
Yes, Your Lordship. Your Lordship, there have been,
Yes.
Your Lordship, there are precedents to that effect. There is no limitation. That is what the council is proposing. There is no limitation.
But you have to justify that cause of action arose, continuous cause of action, that your fundamental rights are now violated. And that is the cause of action to invoke the writ jurisdiction or the jurisdiction of the higher courts.
Yes, Your Lordship. Your Lordship, it is humbly brought to the knowledge of the court that the proposition is silent with respect to when the cause of action arose and why the petitioners are approaching at this particular moment when the plant is being decommissioned is because the petition is also in this petition also invoking the court's direction with respect to handling and management of the post decommissioning waste, which can also cause degradation to the environment. So, Your Lordship.
Aspects of the matter. If plant is closed, some employees or people may face problem of livelihood. On the other hand, if plant is continued, pollution, right to fresh air, to potable water or whatever. So in such situation, what you will do?
Your Lordship, with respect to what the council could best make out from the question of Your Lordship, the right to livelihood issue would be dealt by my co-counsel.
The scope of Article 21 has been so much expanded that right to livelihood also comes within the sweep of Article 21.
Yes, sir.
And right to have fresh air, sound sleep, that
Yes.
all also comes under the sweep for under Article 21.
Absolutely, Your Lordship. Your Lordship, the council is proposing here that there has been a violation of Article 21 with respect to the right to health and the right to healthy environment of the petitioners. And yes, the petitioners are also entitled to the right to development with respect to the functioning of the power plant, Your Lordships. But the council is attempting to highlight that there is an onus on the state with respect to various judicial pronouncements. There is an onus on the state to balance its duty with respect to ensuring the various fundamental rights that are to be provided to the citizens, Your Lordship. So,
Where do you get these duties?
Your Lordship, there was a judgment. If Your Lordship may permit, the council would like to rely.
What part of the Constitution do you get these duties of the state?
Part 4, Your Lordship.
That article.
Your Lordship, Article 47, which says it talks about raising the standard of living of the people.
We'll find, I think, 51.
Fundamental duties.
There are judgments of the Supreme Court.
51G.
You may be right, but that is part of directive principle. 47 and
48A is the one.
Okay, solid. Understood, Your Lordship. The council takes agreements.
That's fundamental duties. Sir.
Fundamental duties also, if you find G, wherein there are some judgments you find.
Aging, yes, Your Lordship. Yes.
G, to protect and improve the G.
Yes, Your Lordship.
Your time is, though we are very eager to hear you further, but
Your Lordship, the council is resting my case. The council would like to.
also included time which we have, I mean, the time for which we have interacted with, that is also added. But even adding that now your time is, but you can
The
continue.
council is finished, Your
You
Lordship.
can continue further for 1 minute to sum up and what are the ultimate prayers in your petition.
Yes, Your Lordship.
Are your ultimate prayers.
Yes. Your Lordship, with respect to the first contention, the petitioners are pleading that this particular petition be declared maintainable and umbrella corporation be declared as state so that this petition can be enforced This claim for compensation can be enforced again against the umbrella corporation as well as the state of Puri Bara with respect to the first contention, Lordship. And the second contention substantiated the first contention with respect to proving that there have been widespread environmental degradation and health has been health effects, Lordship.
Second speaker will have to address first on this, whether the point of jurisdiction has to be argued or at threshold, or because you mentioned that petition is admitted already.
Yes, Lordship.
That you have to address, whether this question of jurisdiction has to be raised at the threshold or after petition is admitted, because if suppose so much time is spent on hearing the petition,
Yes, Lordship.
and in the end we come to the conclusion that, okay, this court has no jurisdiction to entertain this petition. In that case, the entire this time spent on this hearing the arguments and all that. So second speaker will have to start first from that.
Understood, Lordship. Because I would like to invite my co-counsel for the submission. Yes. Much obliged, Your Lordship. It was an honor arguing in front of you.
Lordship, the council seeks permission to appeal the dice. Much obliged, Your Lordship. Your Lordship, issue number 3, particularly, which deals with the right to livelihood violation of the Koila Devi Workers Association. So, Your Lordship, before I start with issue number 3, I would like to clear out a few things. Your Lordship, my co-counsel has dealt with the Babu Nagar Residents Association, which deals with the plight of the residents around the power plant. I would be representing the Koila Devi Workers Association, which is the worker association of Koila Devi Power Plant. So, Your Lordships, the decommissioning of the power plant has led to a right to livelihood violation of the Koila Devi Workers Association. And due to this, the council is here before this honorable court in order to seek compensation from the central government along with the umbrella corporation, Your Lordship. The council would further substantiate his issues in the coming arguments. Your Lordship, before I continue with my next submission, I would like to hand over an annexure to support my case.
What about if you raise the question of jurisdiction? It has to be decided at threshold in the beginning or at the latter stages.
Your Lordship, in this instance, the petitioner is before this honorable court with the help of the PIL. So, Your Lordships, I would like to refer to Bandhua Mukti Morcha, 1984, 3 SEC 161. Your Lordships, in this case, the scope of the PIL was expanded in order to admit petitions where.
And who can file PIL?
Your Lordships, in this instance, the Koila Devi Workers Association are the affected parties because of the decommissioning of the power plant. Hence, we are before this honorable court in order to seek compensation for the same.
Continue, but again, same question would arise. Why not suit in representative capacity before the civil court for compensation? Like you see even the magistrate courts or these courts are powerful. If somebody has come across the case of Ratlam Municipal Council, wherein sweeping directions were given in that case, which and that order is upheld by the Supreme Court. Okay, you continue.
The council would like to highlight.
I want to consume your more time and.
No, Your Lordship. The council will justify the same point, Your Lordship. Your Lordship, according to paragraph 11 of the Moot proposition, the decommissioning is set to happen today, Your Lordship. Hence, the petition has been filed in this honorable court because of the time crunch, Your Lordship, in this instance, because the decommissioning is set to happen today. Your Lordships, the annexure that I just handed over.
We note the writ jurisdiction is the speedy remedy. I mean, normally, and if you know jurisdiction of the civil court, it may take some time for leading the evidence, examining the witnesses. That may be one of the reasons when you are in representative capacity, representing as a class. So that is also one of the reasons to note.
You may have to also answer because your case stands different from your first counsel.
Yes, Your Lordship.
Now you are trying to enforce the statutory rights. That is in a contract between you and the umbrella corporation, you being a worker. Now, when there is a statutory right in the form of an agreement or the employment contract, whether you can invoke the rate jurisdiction when the tribunals are established for those purposes, for that object. And when there is an express contract between you as an employee and the employer and umbrella corporation, how does the jurisdiction 32 will be?
Your Lordships, in this instance, the
You are
KT
not
concluded.
concerned with the environmental. You are cause of action arose when there was an action of the decommissioning of the plant. Yes, so the limitation may not be an issue in your matter. But then you have to see, or you have to satisfy it being in a contractual obligation. Then necessarily the courts or the tribunals, statutory courts and the tribunal may have a jurisdiction, and why the rate jurisdiction, the rate courts will be burdened with that. That would be the fundamental question we may have to answer.
Your Lordships, an order dated November 2022. This was when the central government had passed a notice in order to decommission the power plant, empowered by Section 3 of the Environmental Protection Act. Your Lordship, 60 days, there's a limitation period for the workers to file a grievance against this within 60 days, Your Lordship. That has been fulfilled since this PIL was filed in December 2022. Your Lordships, further, the central government, since it has decommissioned the power plant, has affected the livelihood of the workers, since virtually from today, Your Lordships, the workers are unemployed because the decommissioning is set to happen today. The government has sent out no notices with regard to the compensation packages that they have promised in paragraph 11 of the Moot proposition. Further, Your Lordship, in paragraph 22 of the Moot proposition, page number 9.
You could address this issue by is bringing in the environmental law issues that get involved, since this is an environmental moot. So there is a compensation which the workman could get under the environmental laws. That could be by way of your writ petitions. As a labor class, it is under, so you could address it in that way.
Why not a labor court, or industrial court as maybe, or a tribunal? And why only the regulation? That is the fundamental the issue you may have to answer. That could be the defense of the other side. When there is a remedy is available under the act, why the regulation has been invoked?
Lordships, in this instance, the PIL was filed before the Supreme Court because of the time crunch, Lordships. The decommissioning is set to happen today. The council is seeking for quick justice in order to counter the workers' plight, Lordships, in this instance. Hence, the Supreme Court is the right adjudicating forum for this matter. Your Lordship, the council would like to quote a case from the compendium, flag number 1 of the compendium, Your Lordship. If your Lordships can kindly refer to it, Your Lordships. Flag number 1 of the compendium. Your Lordships, page number 42. Your Lordships, in this case, it was held that in CESC Limited versus Subhash Chandra Bose, it was held that our constitution, its preamble, and particularly part 4, reinforces that socio-economic justice is the bedrock of an egalitarian social order, and the right to social economic justice is a fundamental right. Your Lordships, further, Article 41 talks about right to work, and Article 39A and 39E talks about equal remuneration for both men and women. All of which shows the legislative intent behind the protection of the workers in the state of Asia. Your Lordships, the council would.
Oh, that is not negative obligation of the state in the sense that those are not enforceable in the court of law.
Your Lordships,
Like you say, right to education was earlier article, I think 45. Now 21E. So that is enforceable in the court of law. That difference is there, but of course, you are right, because in few matters, at least the Supreme Court and the High Courts have tried to weigh the balance between fundamental rights and directive principles when it comes to the community rights, rights of the societies. So yes, please.
Your Lordships, the Council would like to further highlight that Article 21 in this instance is violated. Your Lordships, the Council would like to refer to Olga Dallas versus Bombay Municipal Corporation, Your Lordship, which is highlighted as flag number 2 of the compendium. Your Lordships, in this case, right to livelihood and right to life was read hand to hand, Your Lordships. Similarly, in PUDR versus Union of India, right to livelihood and right to work were given a strong stance with respect to right to life. Your Lordship, a similar view was rendered in the case of Delhi Transport Corporation (DTC) versus Mazdoor Congress and others, wherein the court here had stated that the council quotes, "The right to life includes right to livelihood. The right to livelihood, therefore, cannot hang on the fancies of individuals in authority. The employment is not a bounty from them, nor can it be survival at their mercy." The council unquotes. Your Lordships, in November 2022, the central government has stated that the decommissioning would take place according to paragraph number 11, Moot proposition, page number 5, Your Lordship. This is only a period of 3 months, Your Lordship, which is not a reasonable time in nature for a decommissioning of a supercritical nuclear thermal power plant. Your Lordship, secondly, the workers are not equipped with the skills necessary to find a new job. Thirdly, the government has not announced for a scheme regarding provisions to generate employment for these workers. Lastly, the rehabilitating facilities for the same workers have not been discussed by the central government as of yet. Although the decommissioning was deemed necessary, it has caused a catastrophic effects not only on the workers and the government, but it also the central government has not taken sufficient measures in order to soften the damage on the workers, Your Lordships. Your Lordships, the council would now like to move on to the second issue at hand, which deals with the compensation for the same. Much obliged, Your Lordships. Your Lordships, the central government has not provided with the workers with any clarity with regard to the post decommissioning of the power plant since November 2022. The same has been highlighted in paragraph 11, page number 5 of the Moot proposition. There is no scheme with regard to upliftment of the workers, provision to grant them employment opportunities after the decommissioning of the power plant, that is today, or has there been discussion regarding the resettlement of these workers to 285 other such power plants that have been mentioned in the Moot proposition. Your Lordship, there is no specified law that deals with the compensation for the workers of the Koila Devi power plant. But if we use the ratio given in Amarnath Shrine in Ray versus Union of India, we can clearly see that the court had held that if there is a violation of fundamental rights, it is the state's duty to step in and protect the rights of the people. Here, granting compensation would be an apt method to deal with the workers' plight, Your Lordships. Your Lordships, the committee proposed by the central government with regard to the compensation and the decommissioning of the said power plant. This has been mentioned at paragraph 22, page number 9 of the Moot proposition, Your Lordships. So, Your Lordships, this committee that the government has proposed does not involve all the relevant parties in dispute in this case. Your Lordships, the petitioners would humbly like to pray before this honorable court to implead us as a party in the committee in order to further negotiate the compensation packages that the workers would end up getting after the decommissioning of the power plant. Your Lordships, the council would like to hand over an extra in order to support its submission. Your Lordships, these are the prerequisites under Section 25N and Section 25F of the Industrial Disputes Act that has to be followed before the retrenchment of the workers of a coal power plant, Your Lordships. So there should be a 3-month notice period that has to be served before the retrenchment of these workers, stating the reason behind why the retrenchment has taken place, Your Lordship. The same in this case has not occurred.
For the more reasons, you are invoking these provisions. So you have to invoke the jurisdiction of industrial court.
Your Lordship, the council is just highlighting these points.
Now, broadly, you can say, because of decommissioning, they will be deprived from their livelihood, and therefore, in urgency, you have invoked the writ jurisdiction.
Yes, sir.
Otherwise, for the enforcement of this, industrial court is there. And when there is a specific remedy, specific statute is there, whether the writ courts can invoke the writ jurisdiction ignoring the specific provisions meant for the cause. That is also.
You are relying on the judgments, as you said, Olga Davis. called as a Tannery's case in the Kolkata matter. The workforce was unorganized. And in Olga Perez, it was in the case of the hawkers. And demolition notices were issued. And there was a core question was the source of a livelihood. Because they being the unorganized workforce, there was no contrast between the workers and the what is stand for the different duty? Because if you are invoking the 75M, that presupposes there was a contract of employment between you and the employer. So how these two judgments of the Olga case and Tannery case in the
Your Lordships, the Council would like to clear himself before he moves forward. Your Lordships, this current case is very clear, Your Lordships. There are two parties that the compensation is being sought from. One is the central government and one is the umbrella corporation, that's the employer for the said workers. Your Lordships, umbrella corporation in this instance is liable, as my co-counsel has proved, that they are one of the most contributing factors to the environment, which is the reason behind the decommissioning in the first place, Your Lordships. So this proves that they are liable in order to pay compensation to the workers, as well as central government is liable to pay the compensation to the workers because of the decommissioning of the said plant and due to the sudden decommissioning of the same, Your Lordships.
Council, when you're talking of breach of the contract with the employer, you also have to keep in mind the breach of the environment, the compensation that would be need to be given to the people who have suffered because of the plant. So that needs to be balanced out. And how would you balance that? What are those principles which balance economic development and environment?
Your Lordships, in this instance, the state of Desh is trying to transition to a renewable source of energy, Your Lordships. The Council would also like to hand over an annexure to support the same, Your Lordships.
Logic, try to develop this point. Material is all right, but what is that logic? What is that principle? Like your colleague mentioned about the polluter pay principle. So what are those principles that govern this?
Since there should be a balance between right to life, right to development, and right to livelihood in this instance, to balance out all the necessary petitions in this instance, the Council for the Petitioners has one proposal to make to this Honorable Court. Your Lordships, the Council would like to hand over 3 annexures in order to support the same submission.
Part of the principle of sustainable development.
Yes, Your Lordships.
Sure. Throw some light on that.
Your Lordships, the principle of sustainable development talks about sustainably developing with the limited resources that one state has. Your Lordships, in this instance, if the current plant in question, which is a coal power plant, if it's replaced by a natural gas power plant, after taking sufficient measures, the cost at the start would be higher, Lordships, but this would end up retaining the workers, reducing the pollution, at the same time balancing right to livelihood, right to life, and the workers' right to livelihood, Your Lordships. So, Your Lordships, this is one of the proposals that the Council has made. Your Lordships, apart from this, the Council has 2 other prayers to seek before this Honorable Court. That is either to give the options to the workers in order to choose between granting compensation for their right to livelihood violation or to rehabilitate them to one of such other power plants in the state of Desh, Your Lordships. The same has occurred in 3 other such power plants, which the Council would be quoting. Your Lordships, Haryana Power Generation Corporation Limited. Your Lordships, the Panipat power plant in Haryana had been decommissioned by the state government, Your Lordships. The Council is just drawing inference in order to support its analogy. Your Lordships, in this case, all the workers were decommissioned and the workers were granted compensation via Section 25F of the Industrial Disputes Act. Further, the Council wants to submit that the workers also had been given an option to be re-established in another power plant in the NTPC, Your Lordships. In this instance, since KDPP is a coal thermal power plant and there are 285 such other power plants in the state of Desh, the Council would like to be the Council would like its clients to be rehabilitated to one of such other coal thermal power plants, Your Lordships. Further, Badalpur and Rajghat power plants, Your Lordships. Both of these power plants have a very similar fact sheet to what we have in the current case, Your Lordships. Your Lordships, in this instance, the central government had decommissioned the said power plants for environmental reasons, Your Lordships. The same has been fulfilled in this instance. Further, the workers had been given compensation via Section 25F, and further, the workers were also given VRS packages in Rajghat power plant, Your Lordships. Any of these remedies can be sought by the central government in this instance. The petitioners are open to the same. The quantum of the compensation is a policy decision. The petitioners are completely aware of that. Hence, the petitioners are just asking to be implemented into the committee in order to discuss and negotiate the severance packages to be provided to the workers, Your Lordships.
What is your main prayer?
Your Lordships, the main prayer in this instance
Is to implead in that commission which has been constituted to look into the grievances and award the compensation. Only that relief you are.
Your Lordship, there are three reliefs that the petitioners are seeking before the Honorable Court. Number one is compensating the workers for right to livelihood violation. Number two is rehabilitating them. This option should be given to the workers, Your Lordships, because it has been given in Badarpur and Rajghat power plants. Your Lordships, thirdly, is to implement the strategy that the petitioners have suggested before this Honorable Court, that is to convert or repurpose the current plant into a natural gas power plant, Your Lordships. So these are the three prayers that the Honorable, Your Lordship, the petitioner has before this Honorable Court. Your Lordship, saying this, the Council would like
to hear your arguments, but your time is over, I think 3 minutes back.
Yes,
But we have added the time of this dialogue also, 3 minutes. So
Your Lordship, the Council would like to conclude. Yes, the Council would just like to state its prayer because the Council is done with the submission. Much obliged. In light of the facts of the case, issues raised, arguments advanced, and authority cited, the Council, on behalf of the petitioners, humbly pray before the Supreme Court of Pesh to adjudge, direct, and declare that this Honorable Court has jurisdiction in this case and is the appropriate forum to adjudicate this matter. The umbrella corporation in the state of Puri-Para are jointly liable to pay compensation to the residents of Babunagar. The umbrella corporation and the government of Desh are jointly liable to pay compensation to the KDPP workers. A cumulative environmental impact assessment be conducted in the city of Babunagar in order to further understand the impact of the power plant on the environment, Your Lordships. Lastly, Your Lordships, a neutral committee be constituted, including experts, all necessary stakeholders in this instance, that is KDPP, Umbrella Corporation, and the state government, into this committee in order to further negotiate and come up with a sufficient manner in order to deal with the decommissioning in the said instance, Your Lordships, all of which is most humbly prayed. The petitioners would be grateful if Your Lordships admit all of these prayers. Yes. It was an honor arguing before the court.
Yes,
Permission to hold the right.
yes, come up with some case law you will discuss.
Readings to the bench. The council seeks permission to address the bench collectively as your lordships. Your lordships, this is the council for the respondents in the case of Babu Nagar Residents Association, BNRA, versus the state of Puri-Baran Umbrella Corporation, which has been clubbed with the matter of Koila Devi Workers Association, KDWA, versus the Union of Desh. Aided by a learned researcher, I am council number 1, your lordships, and would be dealing with issue number 1, 2, and 3, and would be taking 20 minutes of this court's precious time. And my co-counsel would be dealing with the 4th issue and would take 18 minutes of this court's precious time, leaving 2 minutes for our revisions. If the lordships are well versed with the facts, the council seeks permission to proceed with the arguments advanced. Much obliged, your lordships. Your lordships, in issue number 1, the council seeks.
Can within minute you can narrate the facts. The first column is for marks for marshalling the facts and Just see, prepare for any matter. How you are at very early or initial stages. Your preparation is wonderful, your may be wonderful, but without looking to the papers, you must be able to address the court on facts. Yes, this is what the facts in support of this proposition. It is too early to expect from you. But that is how in future, maybe after you become lawyer, register yourself. Yes. It's too much expectation from us, but don't get discouraged by that. Yes. Yes.
Your Lordship, the facts of the case are the Koila Devi Power Station is a coal-fired thermal plant located in the capital city of
In short, you tell, because they have already narrated the facts. So we take it that
Your Lordship's Koila Devi Power Station is a plant located in the capital city of Babunagar, which is in the state of Puripara. Your Lordship, this plant was built in the year 1998 to the year of 2002, which is uh, under a which was built under a public-private partnership between the state of Puripara and Umbrella Corporation, which is established in the UAE. Your Lordship, it is established according to the bilateral investment treaty between the Desh and the UAE. Your Lordship's Umbrella Corporation invested $80 billion during the establishment of this power plant in expectation of fair and equitable returns. Your Lordship, ahead of the 27 COP, in November 2022, the PM of Desh announced the decommissioning of this thermal power plant. In pursuant to this, Your Lordships, BNRA approached the Supreme Court under Article 32, claiming that the residents' right to healthy air under the Air Prevention and Control Act 1981 has been violated. And similarly, KDWA filed a public interest litigation under Article 32 against the central government of Desh, demanding compensation for loss of livelihood. Okay. Your Lordships, the council seeks permission to proceed with the issue. But Your Lordships, in issue number 1, the council would establish that the writ petition filed before this honorable court is not maintainable as an alternate remedy of approaching the NGT is available. Your Lordships, the petitioners are, this will be contended in a twofold manner, Lordship.
Tribunal.
Your Lordship, this is a matter pertaining to the third party claim, and arbitration can be only done between two parties in which the contract sustains. Therefore, Your Lordships, arbitration clause has been not mentioned, has been not contended from the respondent as such in this petition. It was just a public statement made by the respondent, but as such during the violation of this writ, no such contention has been raised by the respondents.
You're supposed to assume many things. So it's okay. To address it in that way.
This will be continued, this issue will be continued in a twofold manner. Whereas the first sub-limb is that petitioners are required to exhaust all local remedies before moving to this honorable court. And the second limb is that the matters and questions pertaining to this petition falls directly under the jurisdiction of NGT. Your Lordships, the Council for Respondents acknowledges the importance and the powers Article 32 vest to this honorable court. But Your Lordship, this power should be used prudently in cases where no alternate remedy has been available. Your Lordship, in the present matter, the petitioner has an option of approaching the National Green Tribunal, which has been established specifically for matters dealing with environment.
You're saying that nobody can approach a writ court if there is an alternate remedy available?
No, Your Lordships. The matters in this petition are clearly regarding to environmental degradation, and the petitioners are seeking compensation from the respondent, which directly is the focus.
Environment degradation or compensation that you have approached this court?
Your Lordship, the respondent submits that there has been no environmental pollution, and moreover, compensation cannot be paid by the respondents to the petitioner. Your Lordship, it's pertinent to note what the relief the petitioners are seeking for, and therefore, as the relief falls directly under the jurisdiction of NGT, they should be directed towards it. Your Lordships, it should be noted that the petitioners are filing a case claiming that the right to healthy air as per the Air Act has been violated, which is mentioned in Schedule 1 of the NGT. Your Lordship, if you could please turn to Section 14 of the NGT Act. Are the lordships on the same page? The lordships section 14 provides the jurisdiction powers to settle disputes. It states that the tribunal shall have jurisdiction over all civil cases where a substantial question relating to environment or including enforcement of any legal right relating to environment is involved, and such question arises out of the implementation of enactments specified in Schedule 1. Moreover, Lordship, if you could please look into section 15, which provides the jurisdiction of NGT to compensate and provide relief. The tribunal, it states that the tribunal may, by an order, provide relief and compensation to the victims of pollution and other environmental damages arising under the enactment specified in Schedule 1. Your Lordship, it's very important to note that the damages the petitioners are claiming is from the enactment which is mentioned in Schedule 1 of the NGT. Moreover, Your Lordship, as my learned opposite counsel specified, the facts are signed upon how BNRA is incorporated or not. Section, if you could please refer to section 2, clause G, Your Lordships, of the NGT Act. Your Lordships, it states that what a person means. And under section 2, clause J, clause 5, it states an association of persons or a body of individuals, whether incorporated or not. Your Lordships, it's pertinent to note that these matters involve environmental degradation questions which are falling under the jurisdiction of NGT, and moreover, it would be beneficial and effective for the petitioners to ask compensation if they went to NGT if they go to NGT regarding this petition, rather than filing and wasting the precious time of this court. Moreover, Lordship, the fact that NGT has, as its bench, has judicial and scientific experts makes it more effective and efficacious for the petitioners to approach NGT in this present matter.
So that section which deals with compensation?
Your Lordships, it's section 15 of the NGT Act. Clause number 1, Your Lordships, the tribunal, if I may state, the tribunal may, by an order, provide relief and compensation to the victims of pollution and other environmental damages arising from the enactment which the petitioner.
One thing, if there is a specific act and it provides for a particular matter, can that matter also be taken up by a writ court?
Indeed, Your Lordships. But Your Lordships, as already mentioned in the preamble of NGT, it's a specialized tribunal and should not be bypassed in order to give the
Case law.
Your Lordships.
Tribunal, it cannot be bypassed.
Your Lordships, the petitioners are, the respondents are relying on the preamble of NGT, which states how a specialized tribunal has been formulated specifically to deal matters of environmental. Moreover, Your Lordships, in any infringement of right will obviously happen if there are matters of environment, and this.
Have you noticed any judgment, pronouncement of the Supreme Court or the High Court, wherein view is taken that expertise is available with the NGT and therefore entertaining directly the writ petition may be discouraged? There might be one of the valid point which you have argued is expertise, because the experts are there in NGT and therefore jurisdiction of the NGT may be invoked.
Your Lordships, it's mentioned in page number 21 of the compendium submitted that in the Municipal Corporation of Greater Mumbai versus Ankita Sinha and others, this court held that the mandate and jurisdiction of NGT is therefore conceived to be of widest amplitude. Your Lordship, this is a specialized tribunal dealing with environmental concerns and have widest amplitude, and the petitioners with the relief they are seeking moreover falls under the jurisdiction of NGT. Therefore, Your Lordships, the council states that as an effective and alternate remedy is available, the petitioner should move to the alternate remedy rather than wasting the precious time of this court.
Why the NGT will have?
Your Lordship, Your Lordship, the petition, the reason the petition has been filed is asking for compensation according to the pollution which has been filed, which has been caused in the state. Moreover, Lordship, it should be noted upon the petitioners are stating that it's a matter of urgency. Therefore, they should have approached the High Court of the state because it's a state-centric matter, and the operation has been called operation of the thermal plant is state-specific. Therefore, Lordship, High Court would be more effective if they want to invoke a writ jurisdiction over this matter. Therefore, Lordship, the petitioner, the respondent submits while concluding issue number 1 that the writ petition should not be maintainable as an alternative and effect.
the jurisdiction of the High Court is invoked and Supreme Court, because ultimately it will make difference.
Your Lordship, it's just the argument presented by the learned professor to council that it's a matter of urgency. The council just wants to state that it's state-centric matter, and if it is a matter of urgency, they should have gone to the High Court of the specific state. This is an argument presented in response to the argument presented by my learned professor council. Your Lordship, if there are no further queries regarding question, issue number 1, the council would like to move to issue number 2. Your Lordship, much obliged, Your Lordships. Your Lordships, in issue number 2, the council will the council seeks to establish that the writ petition which is filed against a private corporation, which is umbrella corporation, is not maintainable, as umbrella corporation is a private corporation and cannot be construed as a state under Article 12. Your Lordships has humbly submitted that umbrella corporation is neither a state nor a state instrumentality, and fundamental rights cannot be claimed against it. Your Lordship has specifically mentioned in para 9 that the power station, para 9 of the fact sheet, Your Lordships, that the power station was built upon.
Or at the cost of reputation. When you argue the matter, first you have to invite attention to provision. Right? That this is what the Article 12. Writ can be issued against whom? And this private corporation doesn't fit in Article 12. And then
If you could please turn to para 9 of the fact sheet provided. Your Lordship is stated in the para that the power station was built upon the investment of $80 billion, which was invested by this corporation. It was invested in expectations of fair and equitable returns, and in accordance with the BID signed between both the Lordships. It should be noted upon Your Lordship that umbrella corporation is only an investor in the power station and has no control over the operations of the thermal power plant. Your Lordships,
So investments that they have made.
Your Lordships, it was the investment contract which was made between the Union of Desh and the umbrella corporation drops from the bilateral treaty signed between the two nations, that is Desh and UAE. With the name of the bilateral treaty itself is
Have a legitimate expectation that when it invests money, it will get the returns it expects to.
Indeed, Your Lordships, it's true that they have some vested interest, but it's only
Not vested interest.
Indeed, Your Lordships, but it's only pertaining to
That's a contractual interest. It's a contract which they have entered into.
Your Lordships, the investment from the investment which has been done by the umbrella corporation is being protected by the bilateral treaty signed between both the nations. The fact that they have invested so much money, they have been safeguarding the investment with the help of the bilateral investment treaty, and therefore they were only the investors in the and have no hand in the operation of thermal power plant.
You are an investor. You did not expect that some money should come to you and suddenly some expropriation takes place and you don't get any money.
Indeed, Your Lordships, but Your Lordship, this would not conclude to the fact that as being an investor, I have some control over the operation of the thermal power plant. The council only submits that the umbrella corporation is only an investor and all the operations and management functions were being done by the state itself of operations of thermal power plants. Moreover, Your Lordships, if there are no further queries, the council would like to resume with the arguments.
suppose there is a bilateral treaty, but that is in conflict with the constitutional provision or the statutory provision. In that case, how to deal with the situation?
Your Lordship, this question relating to the bilateral treaty will be dealt by the council. Because of it paucity of time, I would like to
No, there is no paucity. We are allowing you further.
Indeed, Your Lordship. But Your Lordships, the council seeks permission to resume with the arguments.
Time is over. 4 minutes and time consumed by us further 2 minutes. So 6 minutes.
But like Your Lordships. Your Lordships, proceeding with issue number 3, the council in this issue would submit that the operations of Koila Devi thermal power plant did not infringe on the residents' right to clean air and on environment. Firstly, Your Lordships, this will be contested into a threefold manner. Firstly, the thermal power plant is subject to strict guidelines and oversight by the regulatory bodies of the state. Second, your lordships, the power stations serve to meet the electrical demands of the city. And last, your lordships, the state government and the umbrella corporation, which are the respondents in this suit, are not liable to pay any compensation to the petitioners. Your lordships, moving with the first limit of the argument, it's humbly submitted that the thermal power plant are continuously monitored by for environmental hazards by a number of regulatory bodies, which is including the State Pollution Control Board, uh, which has been established by virtue of Section 4 of the Air Act. Your lordships, it's humbly submitted that to eliminate pollution, industries cannot be eliminated. Moreover, your lordship, there are reasonable standards accepted within which the industries are supposed to work. Your lordships, it's submitted that because of the fact that Koila Devi station was regulating within these yardsticks, it has been rated supercritical in its efficiency, and it's written in the fact sheet, your lordships. It has been rated supercritical in its efficiency. Therefore, your lordships, when a degree of pollution emitted.
Convention. Yes, so what does that deal with? No, that's all right, but then what is the principle of environment that is being dealt with? Can you throw some light on sustainable development?
Your lordships, the principle states that development cannot be done on the cost of hampering the environment. But your lordship, this should be referred also that development cannot be stopped in order to preserve the environment, because right to development is, your lordship, equally important. Your lordships, that the respondents only want to throw on the light that the fact that the fact that the Koila Devi power station was regulating and working under the yardsticks prescribed by the State Pollution Control Board. This is the very reason it has been specified as a supercritical insufficiency. Therefore, your lordships, when the degree of pollution emitted is well below the prescribed limit, it cannot be said as an invasion of Article 21. Moreover, your lordship, the petitioners have also failed to establish the nexus between the high AQI of the city and the working of the Koila Devi power station, and has falsely accused the station of causing air pollution. Your lordship, if there are no further queries, the council would like to move further with the next limb of the argument. Your lordship, in this argument, the council will be stating that the operation of the thermal power plant was functioning to meet the electrical demands of the residents of Puribad. Your lordship, the power station has not violated the fundamental rights as already established. On the contrary, it facilitated the right to electricity. Your lordships, the electricity which was produced by the operation of thermal power plant has been providing 30% of state's electricity, which allow them to pursue the right to development. Although it's not a fundamental right, your lordships, it's fundamentally very important to have access to electricity in order to satisfy the basic human needs, which essentially is what Article 21 is, your lordships. Therefore, your lordships, moreover, your lordships,
Electricity to be a fundamental right.
your lordships, in the case of Ashish Gupta versus Tata Power Distribution, the court rightly held that electricity is one of the fundamental rights required for life, which essentially what Article 21 is, your lordships. Moreover, your lordships, it's mentioned in the fact sheet that how the citizens of Desh are living in economic and energy poverty. Your lordship, the power station was only providing for the very energy they needed and the opportunities and economic stability they needed. Therefore, your lordships, the power station has not violated any fundamental right. Moreover, has facilitated the right of electricity. Your lordships, if you could please provide 2 minutes, the council would like to wrap up the last limb of the argument. Your lordships, it's humbly submitted that the respondents are not liable to compensate the petitioners. Firstly, for the damages they have caused as per the polluters pay principles, because they are not polluters in itself. And second, your lordship, for the damages the decommissioning process poses. Your lordships, the allegation by the petitioners that the operating power plant caused the AQI to go over 500 is very difficult to interpret. The petitioners have not offered any credible source of evidence to support this argument.
It has gone over 500.
Indeed, your lordships, but
it won't hold much water.
Indeed, your lordships, but your lordship, in the month of October, AQI usually exaggerates due to the Diwali celebrations and how the stubble burning in the neighboring city. Moreover, your lordships, the wind speed is particularly very slow in the month of October, and therefore the air pollution stays there. Therefore, Your Lordships, as the power plant has facilitated a right and has not invaded to the right of Article 21, they cannot be considered as a polluter and therefore they cannot be liable to pay as per the polluter's pay principle, Your Lordships. Your Lordships, just wrapping up my argument, the last name of the argument is, Lordship, that the operation of the Koila Devi power station is not responsible to pay for the decommissioning process if any injuries have been caused. This is due to the fact, Your Lordships, that the burden of looking over the decommissioning process shifts on the shoulders of the government of Desh, not not the state government or not the umbrella corporation. Therefore, the central government of Desh is responsible for the activity and will accordingly be liable if any harm is caused during the operation of. Your Lordship, if there are no further queries, the council would like to address this case, and my co-counsel will be dealing with the issue. Much obliged.
And see, most difficult in this process is more difficult than preparing the case is to face the judges. Whenever there is a competition, on each side, minimum one girl student should be there. This side is lacking, but on that count, there is no marking.
Greeting to the honorable bench. May it please the court, the council is here on behalf of Union of Fish and we will be dealing with issue number 4 and issue number 5. Issue number pertains to whether or not the Union of Fish is liable to pay compensation to the workers, and issue number 5 leads to whether or not the decommissioning process is constitutionally valid. Building on to the issue number 4, the council will be arguing it in a threefold manner. Firstly, by establishing that the employers should approach the state government and umbrella corporation as they are their actual employers as per the Workers' Compensation Act. Secondly, Your Lordship, the council will be establishing that the government is not barred from implementing an environmental policy decision, even if it curtails workers' rights. Thirdly, Your Lordship, the petitioner's claim falls under the ambit of right to work rather than asserting right to livelihood. Your Lordship, building on the first thing of the argument, it is humbly submitted that it is to define who an employer is. Your Lordship, an employer is someone who controls or directs an employee under the conditions of an express or an implicit contract, and the one who is compensated with a salary and wage by that specific employer. Your Lordship, as per section 3 of the Workmen's Compensation Act, if the honorable bench will be kind enough to pursue the section 3 of the Workmen's Compensation Act. Section 3 specifies and establishes the employer's responsibility to dispense benefits to an employee in cases of accidental injury or if any occupational disease is caused to the employer. Your Lordship, the employer in this particular matter of the Koila Devi workers is Umbrella Corporation and State of Kodinpara. Your Lordship, as per judgment Mangalore Dinesh Bailey workers versus Union of India, mentioned in page number 77 of the compendium. If your honorable bench will please stand enough to refer to page number 77. It establishes the liability of the person who engages labor or person with ultimate control over the affairs of the establishment to be liable to pay compensation as per the Workmen's Compensation Act. Your Lordship, therefore, it is humbly submitted if the workers have suffered any form of accidental injury or any occupational disease, they should approach the employer, that is the state of Kodinpara, and Umbrella Corporation under matters of labor code, and there is no liability on the government to compensate the workers under this statutory provision cited by the petitioners. And Your Lordship, if there are no further questions, the council like to approach the second of the arm.
Now the workers union not very aware about their rights and all that. They genuinely feel that the jurisdiction of the Supreme Court or High Court, so that we will get speedy justice. Now, in the given case, the higher courts may issue only directions. Okay, establish one committee who will determine the compensation. Fact finding. Livelihood, if somebody is deprived from livelihood, that is breach of fundamental right, whatever, because it's part of Article 21. So what is that inherent wrong in approaching the, under the belief that yes, I will get speedy court. So let us approach the higher court for whatever redressal of the grievance. So what is so wrong or that you should oppose it so vehemently?
Your Lordship, there is nothing precarious.
My learned colleague has said, there's some concept called full and complete justice, which you can only invoke for the Supreme Court. So you can address on that point.
Your Lordship, the jurisdiction or the workers' standard of the workers has not been tested in pursuance of them claiming their infringement of Article 21 that they approached the Supreme Court, but invoking a statutory legislation which specifies as to
There are multiple reliefs they have claimed. Now, in a given situation, they don't know where to go. And they approach the High Court, concerned High Court or the Supreme Court. That you see our fundamental rights of livelihood and other rights, and therefore whatever directions may be issued by the court to do to the state, establish the commission or the committee. That committee will look into their grievances. Like one of their prayer was, they should be made part of the committee or commission who will look into their grievances. So, what is that inherent wrong or?
Your Lordship, the state realizing that there are welfare states have instituted a national fund that would compensate the workers if there is any unique liability that arises of the state the central government, and would be instituted a committee to ensure that compensation is paid on a case-to-case basis if something if the workers have been compensated under the national fund. So essentially, the central government has taken the onus to ensure that the just transition and proper proper accommodation of the workers is pursued with. If that answers your honorable question, developed in the.
You can proceed, but see, person who is facing serious problems, whatever, immediately he feels okay, we should approach to the higher court and our grievance may be redressed speedily. So whether, I mean, there is nothing wrong in approaching the higher courts. Maybe, you see, problem of our society is, do you know the percentage of literacy? How many people reside in rural area? How many knows about their fundamental rights or the statutory rights? So under bona fide belief that yes, I will get immediate justice because somebody is saying, okay, approach the High Court or approach the Supreme Court. So that will get some justice. And then minute scrutiny, which type of violation is there, direct this court, constitute the committee and all that.
Your Worship, the workers are represented by the association, and one of the responsibilities to facilitate the workers' right and ensure that they will be catered to. You pursue which they will approach this court and trying to establish liability in the central government, which is being submitted, that there's no liability that stand as per the obligations or the claims made by the petitioner. Moving to the second of the argument. Your Lordship, the impact of environmental policy decision curtailing workers' rights does not dissuade the government from implementing it. Your Lordship, enhancing environmental standards is the primary goal of environmental policies, and ignoring the significant environment issues can cause detrimental effects on nature, people health, and the economy. Your Lordship, this would require to change the present structure to favor less polluting and resource-efficient economic activity. Your Lordship, one of the repercussions will be the government shutting down enterprises, industries, or establishments. The closure would cause unemployment and economic losses for certain groups, but this is something as established in the landmark judgment of rural litigation and entitlement, Kendra Dehradun and others, mentioned on page number 18 in the next slide. Substantial. Your Lordship, reference can be made to the appendix on page number 147 for one extract, and the second extract is mentioned in the additional next. Paragraph 12, if pursued, can be brought into paragraph 12. Page number 3, Your Lordship. Apologies, Your Lordship, page number 18. 18. It's in the additional next. Your Lordships, it was held by the court that limestone quarries were to be permanently shut down, and the workers of this particular quarry would subsequently lose their jobs. Your Lordship, the court stated that it is a cost that must be borne in order to maintain and safeguard the right of the people to live in an environment that is healthy and minimally disturbs the ecological balance. Your Lordship, moreover, in the present case, although the Union government is decommissioning the Koila Devi power plant, which may give the workers with no choice. Government actions are still justifiable, and the decision is in pursuance of a fair and reasonably executed environmental policy. They have vital reasons to carry out the decommissioning procedure, even though the workers' rights are being harmed. Therefore, Your Lordship, it is humbly submitted that right to clean and decent environment is a fundamental right that comes with a responsibility for both the government and the people to ensure that apologies, Worship, that both the environment and health, human health flowing from economic and relevant activities are to be considered. If there are no further questions, the council like to proceed to the third of the article.
Yes, please.
Your Worship, the council would like to observe the fact that the petitioner's claim fall in the ambit of right to work and not right to livelihood. Your Lordship, the petitioner's claim go beyond the interpretation of right to livelihood and assert that right to work is a part of fundamental right. Your Lordship, the right to livelihood entails a duty on the part of the state to not interfere with someone's way of life in an arbitrary manner. Rather, on the other hand, Your Lordship, the right to work exerts the responsibility and obligation of the government to provide jobs and opportunities to unemployed people, which is enshrined under Article 41 of the Directive Principles of State Policy. Your Lordship, at the present moment, Your Lordship, this is the very solution of the conflict that we do not enforce it within the
Employment or not to have work, that is global problem, not only in India. Now I heard debate of two contesting candidates for the presidentialship of the USA, wherein one who was president at the relevant time, he said, our government has provided job to 1 crore unemployed youth. Another said, what about remaining 5 crores? So that is global problem and unemployment.
Lordship as an obligation.
You may find debate in Constitutional Assembly. Why this part, whatever is provided under Part 4, was not made part of 3 because of this, including right to education, which now is a fundamental right.
Your Lordship, those reasons is the fact that the country has not found it feasible to put right to work under fundamental rights because it does not have the economic capacity to guarantee it at the very moment. Your Lordship, if there are no further questions, the council takes permission to move to the issue number 5.
Yes.
Your Lordship, it is humbly submitted before this honorable court that the decision of the central government to decommission the power plant is constitutionally valid. The council will be arguing this in a threefold manner. Firstly, by establishing that the decommissioning was done to meet state's international obligation. Secondly, Your Lordship, that any establishment precarious to ecology and causing environmental degradation can be restricted. And thirdly, Your Lordship, that the decommissioning notification was drafted under the provisions of the Environmental Protection Act 1986. Moving to
Council, how do you incorporate treaty law into municipal law?
Article 253 of the Constitution lists down and allows the government to enact a particular legislation in furtherance of treaties or obligations. Furthermore, Your Lordship, it was laid down in the case of Gramophone Co. of India and in other Pekin judgments like Welfare Citizens Forum and National Legal Services Authority versus the Union of India, that if rules of international law can be accommodated into municipal law without express legislation if it do not run in contravention to the acts of the parliament.
Discussed in COP 26. Has it already come into our law? Can you say that that is law, municipal law today?
The Lordship, the power and authority to derived from Section 3 and Section 5 of the Environmental Protection Act to meet meet the goals in the announcements stated under the NDC and the USP announcement. It was listed in those particular goals that they, being a developing country, wants to now shift towards sustainable and renewable energy sources. And in pursuance of that, thermal power plants or energy emitting coal emissions will be reduced, and in pursuance of that, the decommissioning processes happen. And this particular matter is precarious to be ecologically balanced and imparts environmental degradation. Your Lordship, as substantiated by the Council already, Article 253 gives the power to the central government to ensure application of international treaty. Though these responsibilities are not binding, there's still a shared objective and common responsibility of all nations to contribute to environmental improvement.
How would the state balance an international treaty obligation versus its obligations to its own citizens? So that's the whole issue now.
One of the obligations of citizens that mentioned in Article 51C is that there is a right, the citizen has a right to healthy and environment, and the state should ensure that the citizen is provided with clean, secure, safe environment to live a healthy and happiness.
But then how would a state balance this? One is your obligation to the international community. And the second is your obligation to your own citizens. What are those principles that a state needs to follow? Is there any case law, any guiding case law on that point? I'm sure there are plenty of them, but you can cite a few.
One of the principles is common and differentiated responsibilities, because Desh is a non-annexed country to this particular agreement. That state, because Desh is a developing nation, it can choose to enact to the obligations of this particular agreement if it has the economic capacity to do so. The state, being a welfare nation, while working in harmonious construction for all rights of the particular groups, is now enacting a particular environment policy to ensure that no environmental degradation is caused. If that answers your own question. Much obliged, Your Lordship. Moving to the second level of the argument, as already established that an establishment precarious to ecology and causing environmental degradation can be restricted. Before moving to this argument, Your Lordship, it also has to be noted that the decommissioning process is a policy decision. This very court has, in number of cases, separated the powers of the legislation, the executive and the judiciary, and has said that they wish to not interfere or adjudicate upon matters of policy decision until an unless proven or fortunate of grounds of malafide, unreasonableness, or arbitrariness. Your Lordship, it is submitted that the petitioners have not contested on the same manners. So it could be in argument stated that this matter should not have been listed before this honorable court because it's a policy.
Commissioning of the plant is for
Your Lordship, they have not challenged the decommissioning process. Your Lordship, we beg your pardon, repeat the question.
This is the policy decision of the decommissioning the plant.
Yes, Your Lordship.
You follow the procedure and the plant is concerned, whether they have questioned it in the petition.
Your Lordship, that has not been mentioned.
How the issue could be raised.
Your Lordship, the power that has been derived in terms of this policy decision comes from Section 3 and Section 5.
So far as the procedure of a decommissioning is concerned, the councils have not addressed at all. So what is the question of framing the issue?
Your Lordship, according to the argument, we are going to substantiate it in terms of the decommissioning notification to drafted under the provisions of the environment.
That is fine, but whether it was challenged.
Your Lordship,
So that has been questioned by the petitioner.
Your Lordship, the fact that it was not challenged is the reason why the council thought it well to bring in light of reality. Your Lordship, therefore, the council would like to clear. Much obliged, Your Lordship, is humbly submitted that the Environmental Protection Act gives wide and ambit powers to the central government to implement and improve environmental quality, manage and reduce pollution from all sources, and forbid or impose restrictions on the construction or operation of any industrial facility due to environmental considerations. Under subsection 1 of section 3 of the Environmental Protection Act. If you lordship will please. As stated, the statute, your lordships.
You can read. Yes.
Your lordship has specified under section 3 of the Environmental Protection Act, it specifies the power of the central government to take measures to protect and improve environment. Clause 1 states that the subject to the provisions of this act, the central government shall have power to take all such measures it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing and controlling and abating environmental pollution. Your lordship, in pursuance of that, section 5 gives the power to give directions to the central government in exercise of its power and performance listed under section 3 of the Act. Your lordship is humbly submitted that this honorable court, under the obligation of providing an healthy environment under Article 21, has made this particular decommissioning policy under the provisional acts of section 3 and section 5 of the Environmental Protection Act. Therefore, your lordship is humbly concluded that the notification of decommissioning the Koila Devi power plant that has been drafted under section 3 authorizes the central government to preserve and conserve the environment and legitimizes the government's decision to carry out the said decommissioning process. The government will also form a committee to oversee the decommissioning procedure and give affected parties compensation on a case-to-case basis. Your lordship, the council, if permission to be given, the council would like to now please. If there are no further questions.
I think time is over. But we were hearing you and we forgot that time is over. So you presented good. Huh?
Can I rejoin the time?
So anything else you want to add? No?
If there are no further questions, the council would like to please.
No.
Yes, and rejoinder.
Your Lordships, the counsels for the respondents vehemently propose that there are other forums and alternative remedies that are there for the petitioners to peruse and resort to. But Your Lordships, the councillors would like to quote Justice V.R. Krishna Iyer's honorable words, where Justice mentioned that when there is a fundamental right violation, Your Lordships are ready to sit as courts of first instance and deal with the matter under Article 32, Your Lordships. That is why, Your Lordships, the councils have approached this court under Article 32 because there is a direct fundamental right violation and the councils believe that the Supreme Court is the most appropriate forum to deal with the matter, Your Lordships. Secondly, Your Lordships, the council said that Your Lordship, the council remembers reading it in a book called Constitutional Miscellany, Your Lordships. Justice V.R. Krishna mentioned. Yes, Your Lordships.
But don't you think that the period, I mean that maybe 70s, those observations are there.
Yes, Your Lordship.
Maybe in 70s. Now, after 42 years, with the passage of time and high courts and Supreme Courts are flooded with the writ petition. Of course, we take it in positive sense that people are approaching, citizens are approaching, means they have faith in higher courts. But see the filing now and what was the filing in 70s. So whether the higher courts can undertake this scrutiny on facts, that is also the matter for introspection.
Understood.
With this passage of time,
Yes, Your Lordship.
hundreds of writ petitions are filed every day. Hundreds, and number is in hundreds, maybe If you take cumulative Nagpur, Aurangabad, Goa, and in Maharashtra, Bombay High Court, thousands of and hundreds of petitions are every day filed. That is also one of the relevant consideration, that which cases may be taken up for hearing, which may not be taken up for hearing.
Your Lordship, subject to the scrutiny of the Supreme Court, Your Lordship. Yes, Your Lordship. The council submits the same. Furthermore, Your Lordship, the councils for the respondents agreed that the state is controlling and managing the power plant, Your Lordship, whereas the proposition is silent on the same. But the council for the petitioners would like to join in on that proposition. So if we agree that the state controls and
Speaker argued on that.
yes, Your Lordship.
He submitted that is not state within the meaning of Article 12.
Your Lordship, the council mentioned that the umbrella, yes, Your Lordship, the council mentioned the umbrella corporation is just an investor and the state is controlling the power plant, whereas the proposition is silent on the same. Yes, Your Lordship. And even if that proposition is agreed to, the test of qualifying a private corporation under Article 12 to an instrumentality of the state, if there is a deep and pervasive control of the state to a private corporation, then we can qualify that particular corporation as stated under Article 12, which furthers our proposition, Your Lordship. Furthermore, Your Lordship, the second council mentioned that closure of the power plant has led to the infringement of right to work and not the right to livelihood of the petitioners, Your Lordship. Your Lordship, the councils must understand that the jobs of all the 600, approximately 600, considering the large scale of the power plant, 3,400 megawatts, Your Lordship, almost 600 people their jobs have been taken away. They are not restricted to work anywhere else, but their jobs have been taken away. And considering the mass scale of the plant, there must be people, their families, they're living in the vicinity of the plant. All of them are dependent on this particular breadwinner of the family, Your Lordships. Therefore, their right to livelihood has been violated under Article 21 and not the right to work has been violated as pointed out by the respondent councils, Your Lordship. Furthermore, last point, Your Lordships, the councils mentioned that the decommissioning took place in adherence to the international commitments and the national determined contributions that the state submitted to the UNFCCC and the Paris Agreement, Your Lordships. But the Paris Agreement explicitly mentions that these NDCs and net zero targets are not legally binding. And the state of Desh being a non-annexed country, it's not mandated to follow the NDC submitted to the UNFCCC, Your Lordships. With that being said, Your Lordship, the councils would like to respect this. Much obliged, Your Lordships.
Your Lordship, the first question we answered in terms of jurisdiction has not been ousted by the respondents. It's just that the direction towards the entity should be done and the petitioners have the right to appeal to that particular order passed by the entity. Secondly, Your Lordship, the instrumentality test cited by the petitioners, in terms of that, if the veil of ignorance has to be opened up in terms of umbrella corporation, and it can be seen that no deep and persuasive control of the state is in terms of the daily affairs of the umbrella corporation. No financial support by the state government is given to the umbrella corporation. Neither there is the board of directors of the umbrella corporation are also not any state entity or any state body or state person is not on the board of directors of umbrella corporation. So, Your Lordship, the third question we answered. Right to work was exerted in terms of the respondent side because 10 new thermal power plants have been established by the central government, but rehabilitation, re-employment can be ensued of these particular workers. That would be all.
Ultimately, what you want to contain. Second point.
Your Lordship, the fact that the umbrella corporation is a climate actor, it does not fall under the garb of Article 12 in terms of other authorities.
About its ability to get compensation
Your Lordship,
in terms of its investment in the country.
Your Lordship, that would be governed by the financial investment treaty, where of course the export price ratio.
Neither of you have addressed us on that in detail, although your bench memorial does contain a lot of it. So how would you deal with that situation? Otherwise, no investor would come into the country.
Your Lordship, the central government has under the national fund will be any party.
Will that national fund be used to pay compensation to parties who invest in the country or to parties within the country?
Your Lordship, it is mentioned in the prop that all affected parties in pursuance of the decommissioning process would be compensated. So if umbrella corporation, it is established as an affected party of that process, then they would be compensated in accordance to the bilateral treatment amount and the national fund. Thank you, Your Worship. It was an honor arguing.
So at least at this stage, I can express myself. Both the sides have done so well and I mean, for me, impossible to draw the line, but I have to go by panel, whatever. And my feelings are that why we are not here from day one of this competition. Other, I think students might have done excellent well, but as a team, they might have lacked something. So it's really, and performance of both the teams, we measure by, see the pin drop silence is there. They are hearing your arguments so peacefully, both sides. So in that sense, and participation itself in the competition, that itself is win, that to show the courage to participate and demonstrate your skills. Now winner or loser, that hardly matters. What is important is participation. And to face the judges, that is most difficult task. When I was on that side, I mean, now some question is asked by the judge and how to answer this. Preparation is easy, but whatever comes in the mind of judge and to answer that, you I mean, rightly and all that without any, from both the sides, without any showing any slightest, I mean, aggression. That is very important. How to take the judges with you is very important. So,
Yes, I just.
and now what I feel when you start first, you should have mastery on facts of the case. Number two, which are the provisions attracted in the facts of that case? And then you show the provisions. And after that job is done, there should be clarity in your arguments, whatever. And after that, to lay support to your propositions and whatever you have shown and pointed out, go to the case law. In every case, it may not be necessary. If the provision is clear and you can establish your case looking to the facts and law, not necessary in every case that you should. Only when you feel that yes, this case law facts are similar and closer to the case of your case, support you cite in support of that case. And all of us we are bound by the Constitution, which is the main source of all the statutory provisions laws. But I have come across one judgment wherein it is observed that whenever there is no specific provision, the Honorable Supreme Court can rely upon the international treaties and can adopt for time being till the legislation is in place. So
I fully agree with what my senior colleagues have expressed after hearing the councils. The only one thing I would like to add is that I found that the coming generation, the new generation is more judgment oriented. I mean, they cite more laws than the judgments rather than not laws. As has been rightly pointed out, we being the judges, we look into first what is the core issue in the matter. And then we see what facts are being pleaded. So the law of pleadings may not be strictly applicable in the jurisdiction. But nevertheless, in this case, I specifically found the decommissioning procedure or the notification has been issued for the decommissioning the plant. The argument was that we had followed the procedure and the notification had been issued. Then it presupposes they had followed the procedure. But that point has not been argued. So, so only anxiety is to see that you have to be a master of facts, master of readings, come up with the issue. And at last, if it is required, then support, bring the support from the judgment. Do not cite the judgment at the first instance. That is only I can just suggest to you. Otherwise, the performance of both the sides was excellent. They were thoroughly prepared. I think because of the time constraint, they did not narrate the facts and mark the facts. As I found everyone was prepared with the facts. Next time, if it is required, I would request the organizers to allow some more time for the narrating the facts and what their pleadings are, and thereafter the issues have been worked out. And the issues could be then addressed to the courts. That's all what I feel.
Just adding to what my two erstwhile senior colleagues have mentioned. Yes, all of you performed very well. It's been very hard to judge. Even internally, it has been hard to judge. What's going to happen between the three of us is different. But even for me personally, between the teams, it was a difficult job. The bench memorials which came to me were quite good. As my very distinguished there mentioned, that you should go to the facts first. But just to add a little bit, the subject matter is such, it's environmental law. And all the principles we derive today come from international treaties. And therefore, the case laws are automatically attached to them. So therefore, it would be difficult to only go on to basic sections of acts. So people have done very well. Your code craft was excellent. The technical knowledge that you exhibited was also pretty good. We weren't as good at our time. I mean, I wasn't as good at my time. You people have done well. And of course, as has been mentioned, sticking to basic principles is always important. Citing case law comes secondary, very true, but try to remember the principles. Whenever you are arguing a matter, always bring the principle out first. That's what the court always looks for. Okay. And coming to the manner in which we disturbed you people, it was deliberate, just to see how you people think on your feet. Because that's what counts in a real court of law. So very nice. I'm told there were some 40 teams which came here and 24 were shortlisted and 2 teams are here. Is it right? And this is a national Moot competition. So wish you all the very best. Congratulations in advance to the winners. I would like to take your leave. Thank you very much. It's been a pleasure this voting season. Thank you.
But Joel, but from our comments, don't gather that now they are not going to decide anything, and because all of us, we have said that both the teams have equally performed and they have performed very good. But now if there is a variation in marks, but don't take it sports.
There is always a winner and loser. But as my senior colleague pointed out, everybody is a winner because everybody is a participant. So take it in that spirit, right? All right. Yeah. Thank you. All right.
future editions because firsts are always considered very special. A very warm good evening to the galaxy of intellectuals, invited guests, professors, and students. Standing before you are Harshita Sharma and Ayman Singh, the MCs for today's valedictory ceremony of the first edition of Justice Pendse National Environmental Law Moot Court Competition 2023. It is a matter of immense pride to stand before you all this evening. On the behalf of the organizing committee, we are delighted to offer a gracious welcome to all of you today. A pessimist complains about the wind, an optimist tries to change it, and a leader adjusts the sails. The sails for this particular notion were adjusted by a person who is not only a great motivation to all of us, but a visionary, and the person who gave us the belief to bring together this event. He is none other than our beloved Registrar Sir, Professor Dr. Anil G. Warrior. To give a red carpet welcome to everyone assembled here, may I take the pleasure of requesting our respected Registrar to welcome the gathering.
Honorable Chief Guest of the evening, Mr. Justice S.S. Sinde, former Judge of the Bombay High Court, Chief Justice of the Rajasthan High Court, and currently Appellate Tribunal, Rera Appellate Tribunal, Maharashtra. Guest of Honor, Mr. Justice S.K. Shinde, our Honorable Advocate General, Sri Dr. Virendra Saraf, Advocate Nitin Thakkar, who is also our guiding spirit and also instrumental in establishing the environment law chair in the university. Our most respected Vice Chancellor, Professor Dr. Dilip Ukhe, the principal members of the faculty who have come from other law colleges, and all the guests, my colleagues, staff, and the students. Since we are getting late, I will not take much time. I will stick to my assigned responsibility of welcoming you. It had been a very wonderful experience for us for the last 3 days, and I have seen the participants taking part in the competition, and I have also gone through the streamlined link and the feedback received from the judges in the preliminary as well as the quarterfinal, semi-final rounds are that they had a very, very tough time in deciding the winners. But when it's a competition, there should be some winners and somebody have to lose. But when the fight is between equal talents, it becomes more difficult. That was the experience shared by the judges. So I congratulate all the participants for that. And I take this opportunity to welcome all our chief guests, guest of honors, and all the participants to this valedictory function on behalf of the Maharashtra National Law University Mumbai family. Faculty and students, I extend a warm welcome. And I must also note with great sense of gratitude the contributions I have already mentioned in the launching ceremony, the contributions of 3 persons especially, Advocate Nitin Thakkar, then Sri Shashank Manohar and Varsha Manohar, who had been instrumental in establishing this environmental law chair. And the chair, under their guidance and inspiration, could do many things, academic and outreach activities. So, on behalf of the Maharashtra National Law University Mumbai family, we are deeply indebted to you, sir. And our Vice Chancellor, he had always been giving us a lot of inspiration and encouragement. And that is why we could do all these programs. And our another guest of honor, Advocate General, he is also a member of our Academic Council. Similarly, Mr. Justice S.K. Shinde, he been here earlier also when we had a program training judges. Then we thought that whenever we have a
national level moot court competition, we should have his lordship as one of the judges for the program. And the chief guest of the day, this is exception day. When we went to his office for inviting him, even that first interaction was so motivating for us. With his gesture, we have come to a conclusion that this event will be a grand success. Because we were very much skeptical because we were organizing a offline moot court competition for the first time, and we have, as you are aware, we have a lot of infrastructural limitations. We could overcome it because of the determined and sincere effort put in by the team, our students, and also the cooperation of the participants. So thanks a lot. And without taking much time, I once again welcome you all. And also I thank all my colleagues, my faculties, staff, members of staff for all the support. And once again, I welcome you for this program. Thank you very much.
Thank you, sir. Now we would like to facilitate our guests of the evening. Firstly, I invite Honorable Dr. Vice Chancellor Dr. Lee Bouquet to facilitate our chief guest, Mr. Justice S.S. Pendse. Now I would request our Honorable Legal Chancellor to facilitate our guest of honor, Honorable Mr. Justice Lee Bouquet. Now I would request our Head of Department of Postgraduate, Ms. Dr. Anand Rao, to please facilitate our guest of honor, Dr. Virendra Saran. Now I would invite our Head of Department, Undergraduate, Dr. Neha, to please facilitate our guest of honor, Mr. Nitin. Today, we are delighted to have Mr. Nitin Thakur as the honorable guest of honor of the Valedictory ceremony. Mr. Thakur is a senior advocate in the Bombay High Court and is presently serving as the president of the Bombay Bar Association. Sir has provided us with continuous assistance in setting up the Justice M.L. Pendse Chair in Environmental Law in MLA Mumbai, and further has been the principal advisor to Justice M.L. Pendse National Environmental Law Moot Court Competition 2020. His presence has been indispensable for us throughout the course of this moot and for the university. I now take the honor to invite Mr. Thakur on stage to address the gathering.
Justice S.S. Shinde, former Chief Justice of Rajasthan High Court, Justice S.K. Shinde, former Judge Bombay High Court, Dr. Virendra Saran, Advocate General State of Maharashtra, Dr. Dilip Bouquet, Vice Chancellor, Dr. Anil Varya, Registrar, MNLU, other faculty members, ladies and gentlemen. It gives me great pleasure to be with you on this valedictory ceremony of the inaugural Justice Pendse National Environmental Law Moot competition. 2023. Today, those who participated must be heaving a sigh of relief as one has come to an end of an incredible journey, one that has taken you through months of preparation, rigorous research, and countless hours of work, hard work. It has been an honor to stand here before you as the moot court proceedings have come to a close. As law students, you have been given the opportunity to take part in a unique and invaluable learning experience, the moot court on environmental law. The moot court competition has provided you with the chance to develop your legal skills, to sharpen your analytical abilities, and to hone your advocacy skills. Throughout this process, you have had the chance to engage in constructive debate and to challenge yourselves to think outside the box. You have been given the opportunity to work with peers, to share your knowledge and ideas, and to learn from one another. At the end of the day, I'm sure you all are proud of the work that you have accomplished. You have demonstrated your commitment to the law, to justice, and to the ideals that we all who believe in rule of law hold dear. To those who would emerge victorious, I offer in advance my sincere congratulations. Your dedication and hard work have paid off, and you have success. But I also want to remind you that winning is not everything. It is a journey that matters, the challenges that we overcome, and the lessons that we learn along the way. And to those who may not win today, I offer my deepest respect and admiration. Your effort, your patience, your determination have been an inspiration to all. Remember that success is not measured by a single victory or defeat, but by the resilience and perseverance that we exhibit in the face of adversity. Success is not final, failure is not fatal. It is the courage to continue that counts, said Winston Churchill. As law students, one would be constantly faced with difficult cases, challenging coursework, and the pressure to succeed in a highly competitive field. However, it is important to remember that success is not guaranteed and failure is not the end. In life also, we will be facing challenges and encountering setbacks. What matters most is our ability to pick ourselves up, to learn our mistakes, courage in the face of adversity, and to keep working towards our goals. As law students, we are trained to become advocates for justice and to uphold the rule of law. But in order to be effective advocates, we must be resilient, determined, and courageous. We must be willing to take risks, to embrace challenges, and to never give up. So let us take inspiration from Winston Churchill's words and let us remember that success and failure are temporary state. Truly matters to keep fighting and never lose sight of our goals. With courage, determination, and work, we can achieve things and make a positive impact on the world around us. As this moot court competition comes to a close, it's necessary to remember the lessons, the friendships that we have forged, and the that we created. And I'm sure you all will continue to work towards your goals, to pursue your passions, and to make a difference in the world. Justice M.L. Pendse, in whose memory the chair in environmental law is established, was one such individual who was courageous, full of determination, hardworking, and justice oriented, who worked tirelessly to uphold the rule of law. And I'm sure wherever he is, his soul would be more than satisfied looking at the large number of participants. I am told 24 teams from all over the country have participated, and I'm sure his soul will be feeling and must be sending his blessings to all of you. Thank you all for your participation and for the opportunity to be a part of this incredible experience. Let us move forward with pride, with purpose, and with a renewed commitment to the law and justice. Congratulations to all, whether you win or you lose. Each one of you is a winner for simply having taken part in this competition. All the best to you.
Thank you, sir, for your words of encouragement. Our Honorable VC, sir, Professor Dr. Dilip Ukhe, has been the captain of our ship since day one, guiding us on every turn that we took, helping us conduct this competition successfully. Organizing this moot would not have been possible without VC sir's assistance. Hence, I take the honor to invite our Honorable Vice Chancellor, sir, to deliver the keynote address today.
Thank you. Chief guest of today's function, Honorable Justice Pendse sir, Honorable Chief Justice Rajasthan High Court. Honor, Honorable Justice S.K. Shinde sir, Honorable Judge, Bombay High Court. Honorable Dr. Virendra Saraf, Advocate General Government of Maharashtra. The Chairman of Bombay Bar Association and Senior Counsel, Advocate Nitin Thakkar, Registrar Dr. Vadir, all my colleagues, participants, and their student friends. A very good evening to all of you. It gives me an immense pleasure to be here with all of you on this occasion. I recollect and recall the date of 20th March when the meeting was convened by the then Honorable Justice Abhay sir in MNLU, wherein senior advocates, senior counsels, they were present. And at the end of the meeting, I happened to make an appeal to were present here that MLU Mumbai was then just hardly 4 years old. Now it is 8th year. And I made an appeal to all that it needs your blessings, it needs your support. And that support could be in the form of either instituting the chairs or creating an endowments, giving some medals to the students, so on and so forth. After the conclusion of the meeting, Advocate Thakkar sir came to me and myself and Justice Moot were standing, and he asked me that how the chairs are to be instituted and how much money would be required. So at the spur of the moment, in a fraction of a second, it came from me that sir, anything between 2 to 5 crores. Immediately there and there itself, Advocate Nitin Thakkar sir assured that we will give you 2 crores to institute the chair in the name of Justice M.L. Pendse from M.L. Pendse Trust Foundation at Nagpur. Not only that, when I said that even endowments are to be created, could be created, he again asked me what is that, how much money would require. I said, sir, it depends upon in the memory of anybody, it depends upon the person who wish to donate. He said, I wish to donate and create the endowment in the name of my father, Justice G.A. And that's how Justice G.A. endowment was also created, for which Advocate Nitin Thakkar gave 20 lakhs for that. I take this opportunity again, once again, to appeal all those senior advocates, senior counsels, or former judges, to all these dignitaries, to help the university, to guide the university in this way, either instituting the chairs or creating endowments. And even now, since already our 3 batches are passed out, 2 batches have been conferred the degrees in convocation, 3rd one is due. Even the gold medals in memory of anybody, subject wise or course wise or gender wise, whatsoever it is, so that they will feel more encouraged and enthusiastic. It gives me indeed a great pleasure to address this gathering at Justice ML Pendse National Environmental Moot Competition, which is being organized by ML Pendse Chair in Mumbai. This is the first edition. The chair, which was instituted with the support of ML Pendse Foundation, it was not only the moot court competition, but even the research projects, or even we are planning to have and organize some certificate courses or diplomas, since Justice Pendse was keen about the environmental issues and environmental laws. In future, we may organize some courses in environmental law as envisaged by ML Pendse, Justice ML Pendse Foundation Trust, Nagpur. This is also the first national on-campus moot court we are hosting, which makes this day more special. Due to an observable lack of legal academia dedicated to environmental law in India, Justice ML Pendse Chair in Environmental Law aims to foster legal environmental education by promoting and undertaking research activities exclusively in the field in collaboration with national and international stakeholders. We are happy and grateful to ML Pendse Foundation for this constant support. Once again, I express my sincere gratitude on behalf of MLU family to Advocate Nitin Thakkar sir and whole his team for the same. Under the chair, we are also coming out with International Environment Law book, which will be just unveiled maybe within few months, maybe by June or May or June as such, wherein the policymakers, academia, juries, they have contributed, and that would be a handbook, a ready-made handbook for environmental issues, particularly at international level as such. As moot courts provide students with practical learning experiences that simulate the real world environment. Students learn how to research legal issues, prepare arguments, and present them in front of a judge or panel of judges. I'm sure all of you have used these 3 days to explore networking opportunities and learn more about the theme of the moot court. As MC Mehta is known for his public interest litigations, particularly environmental issues, I'm confident that there are some MC Mehta sitting over here. Similarly, Justice Kuldeep Singh, who is also known as a bench judge, maybe who knows that Justice Kuldeep Singh, future Justice Kuldeep Singhs are sitting over here. They will take up the environmental issues in future in their career. I also had the opportunity to go through and review this year's moot problem. Studying climate change is crucial because it's one of the most significant challenges facing our planet. Climate change refers to the long-term changes in global weather patterns and temperature caused by human activities such as burning fossil fuels, deforestation, and industrial practices. Environmental governance in India has come a long way in the past few decades. India has a vast and diverse natural resource base, and the country has recognized the importance of sustainable development. India has several environmental laws, but their implementation has been a big challenge. There is a growing recognition that environmental laws need to be enforced more rigorously, and there is likely to be a focus on strengthening regulatory mechanisms to ensure compliance. India has ambitious targets and is likely to be a continued focus on this sector. The government is likely to introduce new policies to promote renewable energy, such as incentives for rooftop solar and power. India is one of the world's most biodiverse countries, and there is likely to be a growing focus on preserving this biodiversity. The government is likely to introduce policies to protect endangered species and their habitats, measures to promote sustainable use of natural resources. Climate change is likely to have significant impacts on India's environment, particularly on water resources and agriculture. The government is likely to introduce policies to help communities adapt to these impacts, such as developing drought-resistant crops and building climate-resilient infrastructure. Environmental governance in India has traditionally been driven by governmental agencies. However, there is likely to be a growing recognition of the importance of involving stakeholders such as local communities, organizations in decision-making processes. The future of environmental governance in India is likely to be characterized by a focus on strengthening environmental laws, promoting renewable energy, conserving biodiversity, adapting to climate change, and involving stakeholders in decision-making processes. These trends are likely to shape India's environmental policies and strategies in the years to come. These events make the work of Justice ML Pendse Foundation and this Moot code not only timely but also imperative. Strengthening environmental policy making in India is critical to addressing these challenges. Law schools can play essential role in this process by producing skilled professionals who can work towards environmental policy development, implementation, and enforcement. I'm sure that MLL Mumbai will contribute to developing effective and sustainable environmental policies in India through its ML Pendse Environmental Chair. I hope the deliberations and learnings students over the past days can help them engage in lobbying efforts to influence policymakers and decision makers on environmental issues. They can have, they can use their knowledge and skills to design sustainable technologies, develop new business models, and propose policy alternatives. The real success of this event will be marked when we also use our learning to encourage change. I congratulate the organizing team for wonderfully organizing, conceptualizing this dream of ours into reality. And this is not the end, but only the beginning of many more events we'll be hosting under our flagship collaboration. Advocate Thakkarji said that winning and losing doesn't matter. What is important is your participation. You will go out of these 3 days hard work which you are putting with lot of memories, lot of learning, and lot of knowledge. Of course, I congratulate all those who have participated in this first edition of the Pendse Moot Court competition in environmental laws organized by Mumbai, and look forward to meet you again, once again, next year for one or the other occasion, in one or the other, for one or the other reason as such. Thank you so much. Thank you.
Sir, we thank you for your words of wisdom and enlightenment. Today, we have been graced by the presence of Dr. Virendra Sir. serving as a senior advocate at the Bombay High Court. Sir was also recently appointed as the Advocate General of Maharashtra. And additionally, Sir is also serving as the Academic Counsel for MNLU Mumbai. With a wide range of experience, both on and off the bench, Dr. Saraf has been a luminary in the legal field. MNLU is grateful for your presence today, sir. And now I would like to invite Dr. Virendra Saraf to kindly address the gathering.
Honorable Justice S.S. Shinde, former Chief Justice of the Rajasthan High Court. Honorable Justice S.K. Shinde, the former judge of the Bombay High Court. Mr. Nitin Thakkar, the President of the Bombay Bar Association. Dr. Dilip Bouquet, the Honorable Vice Chancellor. Dr. Warrior, the Registrar of MNLU, learned faculty members, and my very dear friends. I'm indeed honored to have been invited today for this valedictory event. And equally, it's my privilege and honor to speak at an event which is held in the memory of a great judge, Justice M.L. Pendse. I've seen Justice Pendse sitting as a judge, as an intern in a law firm. He was greatly respected and admired for his grip of a matter and as to how he used to come to the core and the heart of the matter involved. And a matter before him used to be a very short argument. He had read the papers, used to ask you a few questions. You had to answer it. And upon that answer depended the fate of the matter. It's only fitting that today a competition which intends to train young law students in the art of advocacy is held in the memory of such a great judge. Whenever I attend a moot court competition, I recount my college days. We used to do moot courts. And I remember those days with a great deal of fondness, also to a great extent with embarrassment. Because when I compare our standards with the standards in a moot court today, I'm really embarrassed to think how bad we were and how good you all are. Equally, I remember how painful it used to be sitting in a valedictory event, hearing people speak while you say, come on, get out with our prizes, let us go. But you guys have invited me today, suffer a little while. I've always believed that moot courts are extremely good opportunities because they give you a taste of what practice in court are all about. Also, they may be very different from court, from the reality of court, but they do teach you and teach you in a great way different from what you study as a student. It teaches you how to do intense research on a particular subject. It teaches you to contemplate what the other side may argue, to find answers to it. It helps you contemplate what the judges may ask me and think of answers for that. And then it helps you be confronted with a judge. And I say this not in the context of the judges today, but myself, when I have been a judge in a moot court, confronted with a judge who knew very little about this subject, but was asking you questions which you found, were not the point, but you had to answer it graciously. You had to answer it with courtesy, and you had to answer it in a manner which will satisfy that judge. Now, that is what really practice in court is all about. And that is what a moot court trains you for. Now, moot court also helps you develop your skill of research. And that's where I would like to share with you all that my experience has always been that the law students today resort to an immediate research technology of SCC Online, Manu Patra, some of them use India Kanun, some of them use Google, and that is where you start researching. Now, you all may find it old-fashioned, but I've always felt that these are search engines, not research engines. And you may find it old-fashioned, but I still feel that the first resort should be starting from a bare text and then seeing every possible commentary. And from thereafter, to go to the softwares to see what's the latest case law on the point, because that's where your fundamentals are developed. Because I've always felt, and I still do, that when I open up a commentary to search for a particular point, I start learning so much more apart from that point, because that book is a storehouse of knowledge. When I open it up, I'm reading the book, I learn 10 other points, and that's where you feel enriched, and that's where you feel, that you have learned something much more than the subject that you are looking for. And also, a moot court teaches you how to mold your arguments depending on what the judges, who the judge is. Now, in a college, you all may not know who the judge is or know what his thought process is. But in court, very often, you give me a same case before 5 different judges, I may argue it in 5 different ways. Now, a moot court teaches you, in the first instance, when a judge puts a query to you, you get an idea of what the judge's thinking process is, and you mold your arguments according to that. And that is what, and that lesson that you learn in a moot court. And here I'm share with you all a personal experience of mine when I was a law student and did a moot court. Nowadays, moot courts were not like yours. It used to be very few people doing moot courts. And in the government college where I this used to be held in a big auditorium where all other students of the college used to be also allowed to come. And very often, with the lack of interest in the moot court, we used to gather people and lock the room so that they cannot run away. And therefore, it was a packed hall. The judge asked me some questions, and carried away by a packed hall, I gave some over smart answers. And when the judge left, I was disappointed. I didn't get anything that day. But when the judge left, somehow I got my hands on the mark sheet. And I found that I was effectively second. And the judge had put a -10 against me and put a +10 on the fourth person. And I was pulled down to fourth. I was disappointed. And that evening, I expressed my disappointment to my father. And he said, and that's which I adopted it in my practice every moment of my life, that you've learned your first lesson of advocacy. When you go to court, you go to win a case, not to win an argument. Lose the argument, but win the case. You're never going to win that argument with the judge. So don't try to win an argument. Try to win your case. Lose your argument and win your case. And that is the lesson I learned in a moot court, which I followed every day in my practice. So therefore, every day is a new learning in a moot court. I must also say, and when I say this, I do not mean any disrespect to the earlier speakers, that when I used to sit in a valedictory event, one of the most painful statements I used to find was, winning or losing doesn't matter. It matters. Each one of you all have worked hard. Each one of you wants to win. Losing is painful. But at the same time, I must share something else with you. When you all go back today, any one of you goes out without an award, please realize that winning a prize in a moot court, by no stretch of imagination, nothing about how you will fare as a lawyer. It's far from reality. If you take a moot court as an experience which will leave you enriched, will leave you having learned something, then it's a great experience. But not winning a prize in a moot court is surely not a reflection on your caliber as a lawyer. It is simply a reflection that somebody else said something which appeal to the judge more on that day. That's all it means. Even in court, the best of cases are lost because on that given day, that the arguments of the other side, the case of the other side, appeal more maybe intellectually, maybe emotionally. But that is what courts are all about. And that's a lesson which we should all learn of losing in grace. Because the day in court we decide to take every loss personally, that will always leave you a bitter lawyer. So losing in grace is equally a part of learning to be an advocate. And that's all I'll ask you all to carry with you if you don't take this prize today. It's a valuable lesson that you have learned. I must tell you all that you all are entering into a profession which is much more competitive than our times. Law is a profession of choice now. In my days in college, half my colleagues used to be people who are not interested in pursuing law. Half of them were for a hostel room. Half of them were for railway concessions. Half of them were interested in dramatics, sports. So they just joined law college for the sake of it. And amongst those, we could do well. You all have a much more competitive world. But I don't mean to discourage you all, but all I mean is just put your head down and continue working. The profession always recognizes merit. It may be soon, it may be later, but you need to just continue working because innate talent can be substituted by hard work. Hard work can substitute innate talent, but the reverse is not possible. You cannot substitute hard work just by your talent. So if you work hard, your merit will be recognized sooner or later. And at the same time, in this whole competitive world, my request to you all is don't get burnt out. Don't lose your lightheartedness. Keep your fun alive because keep your hobbies alive because that is what will hold you in good stead when you go into a much, much more harsher world of a real practice. And equally, don't let this competitiveness affect your relationships with your friends, with your peers. Because argue hard, work hard, but don't carry that beyond the room where the arguments go on. In my practice, I've always followed this practice. And I must share this with you that we have had very, very hostile arguments at times. We have had very heated arguments. Maybe we went personal against one another in a moment, which we should not have. It was a mistake. But I made it a point that at the end of the day, I made a call to my other side's lawyer and said, meant nothing wrong. And that's all that was required. And in the bargain, I made great friends at the bar. Who are always my friends. We have a very heated argument in court. And outside the courtroom, we immediately go for a cup of coffee. So that's the spirit I will request you all to imbibe and to try and carry with you. So as all budding young lawyers, after having told you all that I'll not speak much, I've spoken a lot, and I'll end this by saying, I hope to see you all in court soon. Thank you very much.
Sir, we thank you for uplifting our spirits today with the words of encouragement. The panels of the finals today comprise of three erudite personalities from the field of law. The first judge, Honorable Mr. Justice Abhay Ahuja, recently been appointed as an additional judge to the Bombay High Court, graced the campus with his presence. Unfortunately, due to the side schedule, he could not stay for the valedictory ceremony. The second judge on today's panel was Justice Sandeep K. Shinde, who is a former judge at the Bombay High Court. His erudite and inspirational persona has been a source of motivation for us law students to take up the noble profession with utmost sincerity and gratitude. I take this opportunity to invite Honorable Justice Mr. Sandeep K. Shinde to address the gathering.
Good evening to all. The Honorable Justice S.H. Shinde, the former Chief Justice Rajasthan High Court and the Chairperson of the Appellate Authority under Mahadera, Dr. Virendra Saraf, Advocate General of State of Maharashtra, Shri Nitin Thakkar, Senior Advocate, Bombay Bar Association, Dr. Dilip Uke, Honorable Chancellor, MLLU Mumbai, Randy Wari, Registrar MLLU, the respected personalities of the dais, all the participants and the members present in the audience. I won't be taking a long time because we are lagging behind the schedule and the participants are eager for the award ceremony. All the speakers have taken the survey of the events, the activities which are being conducted by the Law University, as to how the National Pendse National Environmental Law Moot competition has been arranged. I must appreciate and thank Sri Nitin Thakkar for his contribution to this university, and a few words I would like to address to this gathering. As Dr. Saraf has rightly pointed out, this moot court competition, or this would be a stepping stone for you to understand or to have a flavor of actual courts. When I passed out my law degree somewhere in 1989-90, though the moot court was not a foreign to the syllabus, but nevertheless, we had no opportunity, at least I had no opportunity to attend any single moot court. So when we stepped into the court as an advocate, we faced many difficulties. Obviously, by recurring appearance in the court, one would learn the advocacy in the real sense. My career as a lawyer was mostly on the criminal law side. My senior with whom I have started my practice used to tell me, the advocacy is nothing but to read the mind of the court. As and when he used to ask me to appear in the bail matters, we had some strategy to open up the matters and invite some questions from the court. And when the question is put by the judge, we would understand the manner in which or which direction the judge is thinking. And then the strategy was always ready. We called a B plan, C plan, D plan, and mold their arguments to put forth their point to convince the court to release him on the bail. I think, but to learn this process, it's not an overnight job. It took around 7 to 10 years to understand the court crafts. I believe that you are so fortunate to have this forum which is being made available to you to learn this court craft at your early stage of practice. You are not even entered into the profession, but I think this experience which you are going to be gaining would certainly enrich you in all respect beyond the knowledge of law. Dr. Saraf has rightly made a distinction between the search and research. None of these softwares have a program or a key for a research, but for search. As an experience as a lawyer, when I was practicing or as a judge, nowadays it has become a trend to, before marshalling the facts, throw some judgments, place some judgments before the court without making the research, and then making the court, burdening the court with the judgment, because as a judge, one has to deal with almost all judgments which are being placed before him. So far as the judge at the High Court is concerned, he may have some liberty to ignore some judgments. But as a trial court judge, whenever the judgments are placed before him by the lawyers, he may have to deal with all the judgments. So I, being a trial lawyer and a trial judge, have conducted not less than 100 trials. And it's my experience that even on a small point, like an identification for age, the lawyers used to marshal or place before me not less than 10 to 20 judgments on one point. In the criminal trials, there are a number of stages, obviously giving rise to a number of disputes and different interpretations. And the judges were really burdened with so many judgments and so many points, which is in fact not necessary. Because in the criminal law, there is no doubt the law of precedent is applicable, but not strictly as in the civil students. My appeal to you all is this: be a master of facts, put forth your case properly on facts, go through the pleadings properly, frame the points of the issue properly, address the court, and thereafter, if it is required, place the judgment before the court. This would give a pleasure to you because you would be having a mastery over the facts of the case. You will be able to convince the court at any point. You may be knowing the law very well, but if you are not a master of facts, I don't think either in the trial court, in appeal court, or in the writ court, you would be able to convince the court. Today's subject, I would like to just comment, though it is being asked under the environmental law, the shades of the environmental law were very few. Most of the participants were required to argue on the contractual obligations and the jurisdiction of the court. So I would request the organizers that in the next competition, a core issue in the competition should concentrate or around the environmental laws. I think it is the need of the time, not only to bring the awareness of the environmental law amongst the lawyers, but among the society also. The criminal lawyer, most of the practice on the criminal side, I found that the environmental laws requires a strict implementation. We see there is a destruction of natural environment by deliberate omission, deliberate acts, or the negligence, which we call as an ecocide. It is not less a grave crime that needs a near or a clear attention. No doubt we have the certain enactments penalizing the persons who are contravening the environmental laws. But I think this area is still grey, and I have not come across any case so far where for the breach of the environmental regulations laws, uh, imprisonment or the penalty of sort has been imposed. It requires attention of the legislators as an institution, as an to implement it. Otherwise, debating this issue in the moot competition would be just an academic. As has been rightly said by the speakers, that we have the excellent environmental laws, but we totally fail on its implementation, which you must be witnessing day to day. We had a legacy of the Chipko Andolan way back in the year 1970 or before that, Sundarlal Kumana, who understood the importance of the trees and the environmental issues. Thereafter, I have not heard of such a Andolan except in Narmada Andolan, where there were environmental issues were taken up. To summarize this, we should not limit, restrict, or confine our attention to the deliberation on the environmental laws, its fine aspect. But in the real sense, we must see that we protect, we guard the environment as far as possible at your individual level. I wish all the participants all the best. I really appreciate the manner in which the participants have contributed their thoughts, their knowledge of law before the panel of the judges. So I wish them all the best. I quite see there is a bright future and wish to say them soon in the court. With this, I thank to the organizers for inviting me to be a member of a panel judge. Thank you very much.
We thank you for your words of wisdom and encouragement. The last judge on today's panel was Honorable Justice Sambhaji S. Shinde, who is the former Chief Justice of the Rajasthan High Court and a former judge of the Bombay High Court. Currently, he is serving as the chairperson of the Appellate Authority under the Maharashtra Real Estate Regulatory Authority. Sir's intellect and experience have ignited many minds to always strive for better in the field of law. Hence, I take this opportunity to invite Justice Sambhaji Shinde to address the gathering.
My esteemed colleague, brother Judge Mr. Justice Shinde, Justice Ahuja left for some personal reason. Learned Advocate General Dr. Saab, Vice Chancellor Dr. Ulfi, President of the Bombay Bar Association, and Senior Advocate, the Registrar of London, Registrar of this University, distinguished faculty members and invitees, partners from law firms, advocates and principals from law college, dear students and ladies and gentlemen. As you know my position, I am the last speaker, and from I think couple of years I am always last speaker. So it has advantages and disadvantages. Last speaker, now what to speak, because all what I have to speak is already spoken. Second, always it happens that you are running out of schedule, and but third advantage is that the third is that there is advantage because everybody knows now this is the last speaker and will be free after And so just I asked one students who passed out in 2017 from the NLO Jodhpur. I will conceal the name and in the end I will tell. I mean, validate this function, I have to speak before the students. So she said, don't test their patience, be brief and finish your speech as early as possible and avoid the long speech. So I'm following that. Few thoughts which I have come to my mind. So far this university is concerned, is a distinguished institute and this competition reflects the same with the hard work and dedication that has gone into organizing this event. It is delight to be invited by MNLU to be a part of Justice ML Pendse National Environmental Law Moot Court Competition 23. This law as a field is growing and expanding as climate change and global warming have become everyday issues that cause great havoc on our environment. Importance and need of environmental laws in such circumstances becomes all the more important. This moot court competition is an excellent opportunity for students to learn more about this field of law as well as sharpen their drafting and oratory skills, both of which are important for up and coming lawyers, not just in litigation, but in all areas of life. Students must utilize every opportunity they can during their campus life to participate in activities that teach them teamwork, patience, and give them a chance to expand their horizons. During the moot court, I observed that the students were well prepared, had conducted thorough research, were able to submit their arguments gracefully. I congratulate all participants on their efforts and hard work. Events such as these are important first steps towards a student's transformation into a lawyer and a member of the legal fraternity. They can take the learning from this into their work as a lawyers and create a niche for themselves in the future. Now, besides this subject, since I have got this opportunity from my experience working as an advocate and judge, I sincerely feel that the students of this university and law students, from the social point of view and for the benefit of society, shall associate themselves in legal aid programs. As you know that Article 39A has been added by the 42nd Amendment, and that quality assistance, though the advocates are appointed through legal aid, that the litigants, they do not get the poor and needy, they do not get the quality assistance, and therefore it is for you to take the call when you will become lawyer, practicing lawyer. At the same time, now importance of pre-mediation litigation and mediation is day by day increasing, and your participation in Lok Adalats is also important. At the same time, there are some social, like Juvenile Justice Act. Earlier, there were 70 sections. Now, in amended act, there are 110 sections. If you go through that legislation, is full protection and care of the children is taken. So it's very important piece of legislation for the society. Now there, as you know that more than 60% people, citizens of this country reside in rural areas. They are dependent upon agriculture. Forget about their rights, some of them are not educated. What we are speaking to them and what they are speaking to us, we are not able to understand because of the barrier of the language. I had occasion to participate in so many literacy camps when I was part of legal aid program and guardian judge for the Ahmednagar districts. We have conducted the workshops for these Adivasi and illiterate people. Is really is for you to take the call when you will be in practical life to help them and appear for them in the appropriate cases. Now, it's also necessary to educate the masses about what are their rights, what are their duties, because somebody residing in Adivasi area is not aware about what are his rights. We had the occasion to participate in one conference that was about how to extend the legal aid before arrest. And in that conference, I did mention that suppose some Adivasi person residing somewhere in forest, he doesn't know whether he is violating law or not because he thinks that the collection of tendu pattas is his right because generation to generation they are residing in the forest. And then he collects it and forest officer feels that he has committed offense, he immediately arrests him. So whether this legal aid will reach to that person, that is necessary to be seen. Then there are important pieces of legislations like POCSO Act, wherein POCSO courts are specially created. Then courts for the children under Juvenile Justice Act. There are labor legislations wherein children are engaged in hotels and at working places. Is is your, I mean, social obligation to help them. And you see, there are lakhs and lakhs of children who are deprived from the education, though the right to education is made fundamental right under Article 21 of the Constitution. Then sometimes you face with the problem that girls are, you know, that trafficking, some minor girls, sometimes women are to be rescued. There, your help may be needed with the help of persons who are doing the social services. Now, one of the important barrier is languages. People don't understand what is going on in the court proceedings. And now the Honorable Justice Dr. Chandrachud, present CJI, now has taken a drastic step, and now all the judgments of the Supreme Court are being translated into regional languages, because ultimately language is a means of communication, and unless that litigant, I mean, made aware that what exactly is going about is in the court, that communication gap will be there. Though you effectively argue the case, even then you will feel that my case has not been properly argued. Now, when you will join the practice, always I feel that who is the complete lawyer who participate in trials and at least conducts few trials by going to the trial court. That is very important, which I had no opportunity because 5-7 years I was in the court. Then I shifted to the Supreme Court, and there I was government advocate for 10.5 years. So I feel personally that I'm not, I'm lawyer for the trial or to appear before. Whenever occasion will come or whenever there will be exams for the judicial officers, please accept it and don't say, no, I have the legal practice and I will not accept or I will not participate in exams. Whatever JMFC, district judges, or when you will become senior, maybe you may be offered High Court justice. That is very important, which one of the worry of the High Court session, I was part of the EDM and also the Collegium of the High Court, and many lawyers who are prospering, and particularly Dr. Siraf and President may excuse me from original side. Even the lawyer at the age of 38 saying, no, 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 I don't want to become judge. Please, whenever it comes to you, please do accept, because society needs your services. And with the experience of 15 years working as a judge, I can convincingly tell there cannot be any other medium than this to serve the society. So this is what I wanted to tell, and my experience with, little I know that students from the national law universities, they are more attracted to the firms because they get handsome amount. Even in first year, I heard that 14 lakhs package is given. So why we should go to the practice and unnecessarily invite the uncertainties? So it should not, because whatever you are studied in national law universities, your language, your skill, whatever your legal acumen, it should reflect in actual practice, and litigants and public should be benefited. Now the secret which I have kept behind is my daughter has passed out NLU Jodhpur in 2017. When I asked her how long I should speak, she said the valedictory function, at the end of function, don't speak long, otherwise students will get bored and you will face the problem. So earlier we used to listen the parents. Now we are, I'm taking her opinion, because whenever I go to any university or where the students are present in large number. So with these few words, I conclude my few words. Thank you so much for your patience, and I really, I confess that I was not so patient like you. Even after I became judge, it took time to settle myself as a judge. And sometimes, as the participants might have experienced today, sometimes the advocates face problem exactly what is that question judge is asking. And how to ask the judge now what your lordships have said is a very difficult task, and you are so polite, and all the participants which we have observed, so patient, no raising of voice, nothing, is really creditable. Thank you so much. Thank you to the organizers and university administration for involving us. Jai Hind, Jai Hind.
Thank you, sir. Our patience was the result of your intellect and the inspiration that we could draw from your words. Finally, after 3 days of toil and trouble among 24 teams that were competing for the trophies here today, awaiting the results of their performance, the time is apt to redeem them from their curiosity. Without much ado, I call upon Ms. Mehvish Kazmi and Mr. Gaurav Balpande to take over the prize distribution ceremony.
Thank you so much, Darshita. Thank you so much, Rahman, for inviting us. So, uh, coming on the very important point. So, the first winner that will be Best Applicant Memorial goes to TC 1212. It's Rajiv Gandhi, National University, Punjab. Guys, please come forward.
I request Senior Advocate Nitin Thakur sir to kindly facilitate the student.
The second prize, that is Best respondent memorial goes to TC 09 School of Law, Christ, University Bangalore. The next prize is for the best researcher, and this is going to a person from team TC 21, Satyam Agrawal. It's Lloyd Law College. Okay, he's not here. Yep, you may collect it.
I would request Senior Advocate Dr. Virendra Saha sir to kindly felicitate.
Next prize is for the best speaker, and this goes to TC 1 to 12. It's Jasmine from Rajiv Gandhi National University of Law and Law.
Now, I would like to request Honorable Justice Amit Chandra sir to kindly announce the runner-up for the Justice M.L. Pendse National Environmental Law Court Competition 2020.
And some voices from both.
You've given it to someone else now. So what was that for? Okay, fine, that's fine. You can give it away. That's fine, sir. As long as they are coming back again to get a better price. So long as they're coming back, get the winner's prize will be okay. That for a winner certificate.
Yes, sir.
No, no, but first give them the winner, then take the runner-up.
Yes.
There is some.
I'm really sorry, there was some exchanging sheets. That's why the trophies got, the sheet got exchanged.
I'll request sir to kindly announce the winners. So the winners of Justice ML Pendse Moot Court competition is Symbiosis Law School, Noida. I request Justice Amhali to kindly felicitate the team with the winning trophy. Winners trophy. Please collect your individual trophies.
I would now like to call upon the Dana that is none other than Christ. Like he said, conviction will not kindly felicitate our Dana.
Ralph Emerson believed that having done it. However, we would falling short of our duty if we do not recognize the thing well done and encourage it. Hence, may I now request our faculty in charge, Mr. Aman Khare, assistant professor and faculty in charge of the Moot Court Society, to deliver the vote of thanks.
Thank you. Respected dignitaries on the dais, off the dais, participants, faculty members, students, ladies and gentlemen. I stand here today with honor and pride to present the vote of first Justice Amir Pendse. I would like to thank the Chief Guest, Honorable Mr. Justice Sambharish S. former Chief Justice, Rajasthan High Court, and Chairperson of the Appellate Authority under Maharega for taking time out of his busy schedule and gracing us with this. Thank you, sir. I would also like to extend my grateful gratitude to our esteemed guest of honor, Honorable Mr. Justice Sandeep Shinde, former Bombay High Court and Mr. Justice Abhay Ahuja, Judge, Bombay High Court, for judging the findings that will aid them in future endeavors. On this occasion, we are grateful for the august presence of Dr. Viren Saraf, Advocate General of Maharashtra, and our Principal Advisor, Mr. Nitin Thakkar, Senior Advocate, Bombay High Court, for their constant guidance and support, which has helped us immensely in making this move a memorable experience. Our guiding light and inspiration behind this competition, Professor Dr. Dilip Uke, Honorable Vice Chancellor, UNLU Mumbai, who has been one of the most significant pillars, who has helped us every step of the competition. Thank you for inspiring us. We could not have achieved any of this without the able guidance of Professor Dr. Anil Valle sir, Registrar, MLU Mumbai, who has been our constant source of energy, strength, and guidance. I would also like to thank Dr. Kiran Rai, HOD and Dr. Anand Rao, HOD PG, Assistant Registrar Academic Mr. Sajid Sheikh, and Assistant Registrar Admin Mr. Suraj Palgan for their assistance. My teams comprising of co-faculty coordinators Manish Katia and Manish Katia and Sati Impagire for having the idea that they spent literally sleepless night helping me with to help this moot court come into success. They've handled each problem with utmost passion and dedication for this moot. I would also like to thank Justice Emil Pendse Foundation, the backbone for this competition. Bombay Incorporated Law Society, our supporting partners. Lupify, our gifting partners. EcoRoot and its foundation, Rakesh Khatri, also known as the Nestman of India. SEC Online, our knowledge partner, and Live Law, our media partners, and others who have enabled us to make this moot a grand success. I would also like to thank Mr. Pramjan and Char Kanwaj for their support. Lastly, but not the least, my organizing committee, volunteers, people and non-teaching staff who have been art and development. Without each one of them, we would not have gained experience that we hold in our hearts. They are the real reason that we have come to the finish line of this wonderful journey. My heart is heavy and filled with joy to witness the first edition of Justice ML Pendse National Law Movement Competition 2023 that we have conducted to the best of our capabilities and have taken every possible step to make this move a memorable experience. I wish all the best to all the participants present here today for their future endeavors and hope to see everyone in the next edition of ML Pendse Movement Competition. Thank you.
All of you must have been surprised after vote of thanks, what is there, rather that is the end of the program and everything. Yet there is some surprise. The mistake which has happened at our end, we really regret. And the manner in which the runner-up team took it in their side. For that and their hope to raise as well as their grace befits, they have accepted it. I am very happy to announce that our learned Advocate General, State of Maharashtra, Dr. Devendra Sarabji, graciously, generously announced consolation prize of rupees 21,000 for runner-up. So thank you so much for your generosity and graciousness to encourage them, and I'm confident that will give them the new enthusiasm in their future. Thanks.
I request everyone to stand for the national anthem. I once again thank all the honorable guests, faculty, and participants for being here. Hope